Yes. Yes.
My lord, I want to move a petition, my lord, on behalf of an woman, my lord, declared foreigners by an ex parte decision. Tomorrow, my lord.
Tomorrow, day to tomorrow, whatever is listed. Yes.
Lordship,
Yes, yes.
I'd like to mention item number 7.
Yes.
Petitioner advocate the recitation is not present due to him ground. Kindly,
Item number 7.
yes, sir. Lohit Kumar versus State of
Rohit
Gujarat.
Kumar.
Yes,
So what do you want?
kindly pass over the matter for a day. Petitioner counsel be the present.
Then tomorrow, for a day means when it will be listed?
It is listed after the petition.
You say that. On the prayer of Mr. What is your name?
As Bora.
S. Bora. The matter stands adjourned to adjourned after petition.
After petition. Thank you, Your Lordship.
Yes.
May I I'd like to mention for the listing of an matter, the person is behind, the person is in detention center also.
Just a minute. Yes, yes.
Yes, Lordship, Lordship, the person is in detention center, detention camp in Jorhat.
So what do you want? What do you want? What do you want?
Let this matter may be listed tomorrow.
Tomorrow?
Yes, Lordship.
Okay.
Much okay.
Yeah, please, Your Lordship. Lordship, similar to your ex parte matter foreigner. 29 Lordship, if possible.
Okay, tomorrow, day to tomorrow, the registry will see. Okay. Yes, yes.
Supplementary list for motion item number 15.
May I please, Your Lordship? Lordship, this is a contested case, my lord, relating to foreigner issue, my lord. In this case, my lord,
Contested. What
My
is
lord.
this?
my lord, relating to foreigner issue, my lord. In this case,
Foreigners.
my lord, yes, yes.
Yes, what is the
My lord,
total?
in this case, my lord,
Yes.
to prove the citizenship of India, my lord, the petitioner has adduced the voter list of his grandfather, father, grandmother, all this, my lord. Voter list of 1966, 70, 85, 97, all this, my lord. And
Yes.
to prove linkage, my lord, she has produced one Kabinnama and one certificate from the Gaon Panchayat, my lord. She did not, she is illiterate, my lord, therefore she could not produce any school certificate, my lord. But that Kabinnama and these, GP certificate has been not considered by the learned tribe.
But were they proved by examining the
Yes, yes, my lord. Yes, my lord. Yes, my lord.
authors of the certificate?
Yes, my lord.
Issuing authorities?
Yes, yes, my lord.
Yes, Mr. Sharma. Yes. You will issue notice then?
Yes, yes.
Okay.
But she is outside, my lord.
Huh?
She is outside.
The outside.
Fine.
And Mr.
B. Chanda, my lord.
P. Chandralani counsel for the petitioner, issue notice is number 3 weeks, 4 weeks, 4 weeks, huh? Should be, huh? 4 weeks. Mr. Judicial accept notice on behalf of all the respondents.
No, lord. I am for
1, 2, no, 2, 3, 4.
2,
2,
Four.
3, 4.
no, lord. 2 and 4, lord. 2 and 4.
Well, Deputy Commissioner also will accept.
No, lord.
Okay.
My advocate will. accept.
Okay, 2, 4. Yes, Ms. Gyan for respondent number 1 and 1. And 5 and 6, 3, 5, 6, 3
5.
state.
5 AI only and 6 LDB.
Okay. A. Ali for respondent 5 and L. Devi for 6. And Deputy Commissioner,
Deputy Commissioner government lordship.
yes, with the government council here.
Lordship, you does.
You does. Okay. You does. It has been submitted, the petitioner had not been detained on the strength of the opinion passed by the learned tribunal, if that is so. She may not be, she may be allowed to remain on bail. Remain on bail on execution bail bond of rupees 5,000 security will serve around for which, and she will appear before the SP border
Walpara, my lord.
Walpara, and the SP border Walpara will record the iris and all this thing. Yeah?
Deputy.
Next,
Daily list for admission item number 1.
May I please, your lordships? There is a appeal against the conviction, lordship. The conviction was under 302, lordship. The appeal needs to be admitted, lordship.
and Mr.
V.H. or the.
V. Chaudhary, Learned Counsel for the appellant. Appeal is admitted, call for the reports. Who is the informant?
Lordship, the
Informant
informant
is not
is
made a
not
party.
made a party, lordship. Only the state has been, the informant is the
uh,
father of the deceased, lordship.
So you give a,
Father of the deceased,
yes. So do you have the particulars of the father of the deceased? No,
We do have, lordship.
you have.
We do have,
Can you include him also? Let
As
the
per
father
lordship.
of the deceased,
lordship.
we also included as one number 2. Particulars will be furnished by Learned Counsel for the appellant. And steps will be accordingly taken by a staff post with AD.
Lordship.
On receipt of the LCR, let the paper book be prepared.
that
Highly obliged. Lordship, list after. A date, lordship, list after.
Yes,
List
after
after
the
four-
LCR
3
is
weeks.
received,
once the LCR
LCR
is
is
received,
received.
yes.
Highly obliged.
For orders, item number 2.
2 paper book is ready.
In this case,
Yes. LCR is here, paper book is ready.
who is appearing for the appellant?
There are series of councils. None of them
Appeal
are
has been
there.
admitted, the appellate book is not
Perhaps
ready.
as Borgohai is
But let
there.
us see who is the counsel for the appellant.
Perhaps as Borgohai,
2017 matter,
yes.
Bora, D Bora. Who is D Bora?
Perhaps some councils have
N.
replaced
Mahajan
the others.
for appellant, N. Mahajan. The name is mentioned in the post list.
But perhaps some councils have replaced the previous councils. It will have to be
There are so
advanced,
many
yeah.
councils are mentioned, no? Okay. Since the paper book has been prepared, let a matter, you are there appearing in this case? Item number 2. Item number 2?
Item number 2, paper book is
Yes,
just received, my lord.
you have received.
Yes, my lord.
Okay.
Not for hearing, my
Mr.
lord.
Okay, very well. Your name, Mr.
N. Mahajan, my lord.
N. Mahajan, for the Learned Counsel for appellant, submits that he has received a copy of the paper book. And accordingly, let the matter be listed.
Perhaps the
hearing.
respondent is served, I think so,
Respondent, yes, respondent.
because they have made one respondent.
Who is the respondent? Do you have any idea, Mr. Mahajan?
The informant, my lord, PW1, my lord.
Yes, has been served.
Service report, have not.
Service report. See, unserved notice received from tagged as you are not. So what we can do is that
I think the son killed the father.
addressee is not, huh?
I think the son killed the
Son
father. in
killed the
this.
father.
And the informant is the co-wife, is the stepmother
Stepmother of the.
of the victim,
So,
of the
mother,
appellant.
mother or the stepmother should be there. The informant. Is there any reference to that person in the judgment? How do we, that informant is also not made a party here, was Monju Bora,
Monju, my lord, PW2, my lord.
PWC, no, notice. Or Pathor, Golaghat. And the note says that she has left the place.
She
It
is
is told by
PW.
villagers that she has left the place a few days ago and they are unaware of her present address. In support of fact, the certificate from Gaumbura is also attested. What we can do is that we still appoint a legal aid counsel to represent her interest. That
That
will
will
be
be
better.
better.
That will be better. Office note indicates that though the informant Srimati Bora, office note indicates that those steps have been taken to serve notice upon the informant Srimati Bora. It has been informed the chief judicial magistrate, concerned chief judicial magistrate, the Golaghat, had submitted a report that the villagers had informed that the said respondent number 2 had left the village a few days ago, and the villagers are not aware of her whereabouts. Under the circumstances, it will be difficult to ascertain the current address for the purpose of service of notice. Full stop. In order to protect the interests of the informant, we however proceed to appoint a legal aid counsel. To represent-
He is an amicus, no?
I am a legal aid counsel.
Oh, legal aid counsel also.
So accordingly, we proceed to appoint Mr.
You choose.
U. Chaudhary to represent the interests of the respondent of two, even though no notice has been served upon her. As the matter is, as appeal has been pending since 2017, it should require expeditious disposal. List accordingly, list accordingly for hearing. List accordingly for hearing after the vacation. After the preservation by showing the name of the council for the parties, including Mr. U. Chaudhary.
Obligation.
Item number 3.
Read please, the motion.
You are
The
the
leave
state in the-
application preferred by the state of Assam.
Yes,
Lordship, I have issued, notice was issued to the respondents, but no response was coming up. So this honorable court directed me to take a report from the OC concerned, my lord.
yes.
I have received a report via
What does
WhatsApp.
OC say here? What is the
But
report?
accused person could not be found, as such, your lordship, a copy of the order was served on his nephew, my lord.
So what is the last report? As per the message you have sent?
Lordship, at the second page.
Second page, what does it
Yes.
say?
Lordship, as the accused person, the person concerned could not be found, it was served on his nephew, my. They went to
Okay.
the,
But then see, in a criminal case, service of notice upon the nephew perhaps may not serve the purpose. He has to be, it has to be served on the person concerned.
if it cannot be found, any male member, it can be.
Under what provision of law?
It's there. Your Lordship. Can be.
Can be,
Male
but then, is it the same address? The male
Address
member,
same.
see, address is same address, he must be
Lordship,
staying.
what happened, your lordship, the case was under, because direction was to Morigao PS, my lord. Morigao says the jurisdiction falls under Mikirveta PS. Accordingly, I made the endeavor to serve notice on the OC Mikirveta PS, my lord. And I have sent it to WhatsApp, your lordship. And to my response, your lordship, whatever I have sent, your
No,
lordship.
but then question is whether the nephew, does he stay with him? Because mere relation will not do, they must stay in the same household.
Lordship, report says
Uh,
this OC concerned went to his residence, he could not be found.
And then,
So it was served on him, my lord, on his
no,
nephew.
correct, nephew, does he stay with his, because that also required, because if he does not stay with him in a different house, then
Because
in the
that-
same household, he must be
He
in the same
yes.
household.
As he could
Because,
not be
because
found.
it is a criminal case.
Yes, ma'am.
Because if he is not conveyed to him, he will not know what has happened. If he is in the same household, yes,
Lordship, the OC says, my lord.
in the
he
same
went-
household,
Yes, he went to his residence.
Can you
And
read this? Can you read this? Because it's very, too small to read.
Lordship, yes,
The second page.
I have Lordship.
You can read in, yes, you can read out. No.
সন্মানপূৰ্বক বিনীত নিবেদন হৈছে উক্ত অৰ্ডাৰৰ উল্লেখ থকা ব্যক্তিজনৰ ঘৰলৈ গৈ তেওঁৰ ঘৰত লগ নাপায় তেওঁৰে ভতিজাকক ঘৰতে লগ পাই অৰ্ডাৰৰ কপি চহী লৈ দ্বিতীয় কপি তেওঁৰ হাতত দি দিন ও তাৰিখ বুজাই দি মহামান্য আদালতত হাজিৰ হ'বৰ বাবে কোৱা হয়।
Ms. Bornali Bhuya, learned additional PP, submitted that he received a report from the OC concerned that when a personal was sent to serve the notice upon the respondent number 2, he was not available in his house, and in his absence, the notice was duly served on his nephew,
Debo Deuri.
Debo Deuri, in his house. Stop. However, no one has appeared. When it was served? Served on?
Report dated 28/6, my lord.
When it was served?
28/6.
Or it was served on 28/6. However, none appears for the respondent. Since the appeal is against acquittal of the respondent, in order to ensure that the respondent is present and or duly presented before this court, we will direct the legal aid, which district?
Morigao.
Morigaon District Legal, Morigaon Legal Service, District Legal Service Authority to contact the respondent number 2.
Lordship, yes, Morigao only.
Morigao 2.
Police station में Mikir Beta.
Or
Under
the
the
rest number 2, and offer service to the legal service authority.
Lordship, he is the person in, he was a person concerned of police department. He was an employee. And
Correct.
in his maid was there, Lordship, victim was his maid. Allegation is of 376.
Now, is he still serving in the?
That information I do not have.
Then the police can find out if he was an employee of the police. He was earlier serving the police.
Yes.
Then you serve it. Then we'll insist on serving, because then let him be found out by the police. Why should there be a difficulty on the part of the police authority to trace out their own personnel? Is he still in service? No, you don't know.
Right.
Let the police then kato sab though. However, since it has been submitted that the said respondent was serving in the police, will require the police authorities to verify his whereabouts and ensure service of notice upon him personally. Let the matter be listed after.
The direction to be given.
Yes, full stop. The Superintendent of Police, Morigaon District will do the needful.
It may go through the registry, Your Lordship.
Full stop. Okay. The registry will accordingly intimate the SP of Morigaon District of the order passed by this court today. Copy of this order may be furnished to Ms. Bornali Bhuya, also learned additional PP also. From your side also, just find
Yes,
out,
I
will
will.
from the registry also, they will take the steps. Because it is desirable, because if he is a personal, even if he's retired also, they will be able to find out where he is.
Right.
The SP Morigaon will accordingly submit a report of the action taken by the next date. After the puja.
2017. Item number 4.
For paper book is ready again.
Yes, you are appearing?
Yes.
Okay.
Yes, I have received the paper book.
Okay, it has been stated the paperwork is ready and according to matter being listed for hearing list accordingly.
Obliged.
Item number 5.
Five also paperwork ready.
You are appearing for the?
Yes.
Yes.
Appellant Lordship.
Okay,
Earlier Lordship, PN Goswami was appearing.
Okay.
He was appointed additional advocate.
No.
Now I'm appearing.
okay. It has been submitted, the bar, the paper is ready. And have been submitted and a copy have been submitted the council for the parties. Let the matter be accordingly listed for hearing in usual course.
Let date may be fixed Lordship. After vacation.
No, that after it will come as per your turn, as per the, as per chronology, okay? Your this 2020 matter, so earlier matters will be taken up first, yes.
Obliged. Lordship.
Item number 6.
6 paper book is ready. So,
Yes, you have received a copy,
I have not received.
No
I will
receipt, okay.
receive it today.
let the paper book, copy of paper be furnished to Lana Council for the appellant. Lana, Michael's query, appearing for the appellant. Mr. Gupta, H. Gupta. The matter and thereafter the matter will be listed for hearing in usual course.
Obliged.
Item number 8.
Lordship, here appear on behalf of the MR, on behalf of the Lanas Emagat Query Milo,
Yes.
the paper book has been issued Milo.
Okay, it has been submitted about that the council for the parties have received the paper book. And accordingly, the matter be listed for hearing in usual course. Yes, next.
Item number 9.
May I please tell?
Yes,
LC has been received Lordship.
received.
Lordship will
Okay.
directly restrict to prepare a paper book.
I have the paper book.
Okay, you have got a paper book?
Item number 9. Yes.
Yes,
But I.
but we don't have the paper book in the record.
Huh?
How did you
Oh,
get a
it's
paper
wrong.
book?
It's wrongly shown as item number 9. This
Okay.
is Subut
Since
Saikia.
the LCS have been received, let the paper book be prepared.
Lordship.
Yes. Next,
Item number 10.
May I please, your Lordship?
yes,
Lordship, I am appearing as a legal aid counsel in this matter. From the cause title, it appears that, from the cause list, it appears that LCR has been received.
yes. Since the LCR has been received, let the paper book be prepared.
But I could not go through the office note whether the notice has been served or not, Lordship. There is a office
Respondent is not made a party here.
It has been made a party.
Achha.
Yes. Later on,
That's number
I
two.
have implemented.
Yes. You have taken steps?
Lordship, steps was to be taken by through the section, Lordship.
Notice issued to respondent number 2 by Resta Post. It appears that the notice had been taken for service of notice from respondent number 2. However, there is no however, it is not known whether the same had been served upon respondent number 2 or not. Respondent number 2 is the wife informant, na?
Yes.
Or no? Respondent number 2 is the mother of the
Mother of the victim.
victim girl. Victim
Mother of the
girl.
victim girl.
Victim girl.
It's a case under POCSO.
Let the Golaghat District Legal Service Authority contact the respondent number 2 and provide necessary legal aid if the same is sought for. There is already a direction to the Golaghat District Legal Service Authority for rendering necessary assistance for the purpose of payment of compensation under a victim compensation scheme. White our order dated 27/7/2022. Let the report be submitted by the Golaghat District Legal Service Authority in this regard, and also about the representation about the legal assistance that may be rendered to the respondent number 2 by the next date. Copy will also be furnished to the member secretary of the Assam State Legal Service Authority for intimating the Golaghat District Legal Service Authority for doing the needful. Matter be listed again on Wednesday. Tariq.
God bless you.
1st of November. 1st of November. Item number 11.
Paperwork has been prepared, no?
After vacation,
Records, local records have been received. Let the paperwork be prepared. The matter be listed thereafter for hearing in usual course.
Item number 12.
May I please, Your Lordship?
Shahjahan. Yes, what is this?
So this is criminal appeal against.
Delay, how long? How many days?
1 day delay, Your Lordship.
1 day delay, yes. Okay.
Objection at all.
I'm Mr.
D. Hussain, Your Lordship.
Visalana counsel for the applicant. The present application has been filed for considering a delay of 1 day in preferring the appeal against the order dated 26/9/2017 passed by the learned district additional chief judicial magistrate Karimganj in CR case number 1091 of
Hailakandi.
Hailakandi, but you said Karimganj. See your application, page 6.
This is Hailakandi.
CGM Karimganj, you have mentioned. What is the impugn order?
Page number
Page number?
17 of the main appeal, criminal appeal.
This is Session Judge Hailakandi.
Session Judge Hailakandi.
And then why did you write this Karimganj?
I'm sorry, ma'am.
No, it's not question of sorry, you have to correct this.
I'll correct it.
Correct it, huh? Release is matter? When?
I'll correct it right now, ma'am.
Day after tomorrow. This is matter day after tomorrow.
In my IA, it is Session Judge Hailakandi. No.
Shahjahan Alam Chaudhary is the one.
Chaudhary.
Shahjahan Alam Chaudhary. It's written Karimganj.
In IA, it's my lord.
IA and IA is Karimganj.
It should be
In my
Hailakandi.
IA, it's Session Judge.
In the prayer portion, you have mentioned Karimganj. You correct it.
I'll correct, ma'am.
Oh, yes,
correct.
prayer. Court title it is Session Judge, but prayer it is wrong.
We are not interested in the course title, but in the prayer.
Copy paste created this problem. Copy
If you make a wrong prayer, then we'll be giving you a wrong relief. So correct it.
Okay.
Okay, this is the matter. Day after tomorrow,
I'll be blessed.
the applicant may make necessary corrections in the application. He is allowed to make necessary correction application. Yes,
Item number 13.
This is also a delay, I believe.
this is also for delay.
Yes.
How many days delay?
103 days.
Huh?
103 days.
103
days.
103.
days, 100, century. You have crossed, you have scored century. Yes, anything you want to say?
Anything below 100 days, I don't object. 103, let the matter be heard.
103, yeah, because it has crossed 100, century.
It's crossed 100.
But what is the ground you have mentioned?
Lordship, after conviction, he is behind the bar, Lordship. He is in custody, Lordship. He is
Okay.
the sole bread owner of the family, Lordship.
What is his, what kind of, what was his profession earlier?
Lordship, he is a
He
delivery.
feels he from a very poor family.
Yes, Lord.
Jahan,
There are two, Lordship.
huh?
There are two page 4, Lordship. I have.
There are two. Page 4,
Yes, Lord.
there are 2.
Poor family, he is the only.
Poor family, or old age parents. The applicant is sole animal custody. Father is suffering from severe back pain for the last 10 years. No sufficient means.
These are actually not grounds for delay.
So tell us. Unintentional, and what is the conviction? You have been convicted for what?
Conviction under section 6 of POCSO, Lordship.
Hmm?
Under section
POCSO.
6.
Let the victim be heard before.
Hmm. Okay, yes, we should hear. Okay, we'll issue notice.
Lot.
And Mr. Lane, counsel for the applicant, issue notice in number 4 weeks. I mean, accept notice on behalf of the state. Applicant to take step for service upon response number 2 by rest of post with AD.
Published.
Item number 14.
Yes, any instruction you have received?
Lordship, I have received instruction, Lordship.
Yes, what is that?
Amount has been paid, but
Paid.
Lordship may allow me to file an affidavit, Lordship.
Thank you. You appeared today and you got the relief. Amount has been paid?
It was only for arrears, Lordship.
Arrears,
along
yes,
with the-
correct.
Yeah, along with the dearness allowance from the company.
Lordship, we obtained the inspection from the confirm from the bank, Lordship. Next, day,
Yes.
Lordship. And bank has given the details when it has been paid, Lordship.
Is there a copy of this?
No, Lordship,
No,
I'm
Lordship,
furnishing.
we haven't.
Do one thing, give a copy to her.
I'm furnishing.
That tomorrow, day to tomorrow, tell us, you contact your,
Lordship.
your firm, get it verified. Appears that the amount has been paid in the co. And Miss D. Saikia, not a counsel for the petitioner, also Mr. B. Chakraborty.
1 and 2, Lordship.
Huh?
For 1 and 2.
Then it's CGSC for the respondent 1 and 2. Also Mr. Talukdar for respondent number 3. Nair also, okay, yes, what is your name? D. Mohanto. For respondent number, for the? For whom? Mohanto for whom? Guwahati High Court. Assisting, okay, D. Mohanto assisting UK Nair. Standing counsel for the Guwahati High Court. Today, when the matter was taken up, it has been submitted by Mr. B. Chakraborty, learner CGC, that the necessary arrear had been paid. In this regard, has submitted before this court a letter dated 22/9/2022 from the senior accountant addressed to learner counsel. A copy has been furnished to Ms. D. Saikia, who shall ascertain the same. The matter will be considered again on day after tomorrow. Day after tomorrow or tomorrow? Tell us when you can tell.
Tomorrow.
Tomorrow? Okay, you are certain tomorrow, then we'll close it if he is paid. Huh?
We
Let the mat-
realize, Lordship.
Let the matter be said tomorrow.
Supplementary list. Item number 16 and 17 for hearing.
This was hearing,
My lord, that report has not come as yet. my lord.
okay.
I
Doctor.
understand, my lord, I was told by.
Earlier Gayan was there.
Yes, yes.
Yes, Mr. Gupta, what do you want?
The instruction is that the representation is been considered by the Ministry of Defense and is at final stage of consideration.
But final, but it should be, there should be some expeditious consideration, no?
There are a lot of channels. I have.
No, correct, we understand, but then the matter is before the court. We would expect you to go a little bit, because of that, the proceeding will get delayed. That is only.
And it's not a very ordinary case also, my lord, where allegedly, my lord, 5 persons were killed. There's a CBI report.
Copy of the court of inquiry has been asked.
So when do you
think that-
expect, when do you, because then you tell them to expedite it.
My lord, let it be on 20th, my lord,
28th
19th
of?
we are reopening. 20th or 21st, my lord.
Of October,
Yes, my lord. 19th we are reopening.
okay, 21st, can you get the
My lord.
information?
My lord.
And hopefully by that date, they will have the report. my lord.
Okay. And Mr. Ken Chaudhary, Lionel Senior Counsel. Also Mr. Mohanto, Lionel Counsel, as well as anybody else? No. The petitioners are also Mr. H. Gupta, Lanet CGC, who submits that the matter being processed, process by the competent authority. And since it involves a number of it involves a number of officials, a number of authorities before the. You have applied for that copy.
Yes,
no?
yes, long back.
Uh,
That's why they're.
and before releasing the certified copy of the order of the proceedings, certified copy of the proceedings of the court martial, general court martial or court martial, general court martial.
The reply, it is actually the reply to the letter. We will be furnishing
What?
the reply to the letter. They have asked for the copy of the court martial proceeding.
Either you see, you cannot see to reply today itself. We are taking so much of time. We thought that you are going to give.
Because there are a lot of information which may be or which may not be supplied. So that is.
No, fine, but then that is okay.
The information relating to security of the state, we can understand.
No.
Other than that,
No, we understand. We are not saying, but then if you are saying that to respond to the representation is one thing,
6 months.
and to furnish a copy of the proceeding is another thing. You may not furnish the entire. You may, redact it. You can screen out which you
At
think.
least the operative portion.
At
my
least,
yes,
Yes, that is what is.
So
That is why it is taking time a lot.
matter being processed at various level, because of which it has taken some certain time. We hope and trust that the authorities will do the needful as expeditious as possible. Is delay in consideration of application of the petitioner is causing delay in the disposal of this set of petition, this batch of petitions. Accordingly, as prayed by Mr. H. Gupta, Lionel CGC, the matter be listed again on 21st of October for further consideration.
Deeply obliged.
Sorry, you are paying for? In this case?
And 2 and 3 months.
Okay. Kindly give that for whom you are printing. It will be noted down.
Government.
Yes.
Daily list over hearing list.
Then what is to be?
Hearing
taken
list,
up
item
now?
number 4.
That Friday's matter, Sabul Mandal. Mr. Kuar was doing it.
May I please your lordship?
That group
Huh.
or
A group fighting that INL company.
company matter, yes.
Yes, lordship. Lordship senior is on legs, lordship in code 6. Just after 2 matters is done, lordship, he'll be here.
Till then, what do we do? Any other matter?
Any other, yes, there was another series. Where Mrs.
11 to
We
15.
have to reply. Oh, they have not completed.
11 to 15.
Yes.
Mr. Nath is there. What is your case? Any case? You have a case matter here? Sorry?
In single bench.
Single bench. Okay. Bhuya, you are going to respond to which case, which appeal?
Lordship, 11 to 15,
They have been heard.
it has been heard, but they have some part, Lordship, they haven't completed yet. They said, my lord, I was not there on the last occasion.
11 means Jagdish Diori.
Yes.
Let us see file Jagdish Diori. Who is that? Who was earlier? Jagdish Diori, who was appearing earlier?
Lordship, set of lawyers are there.
Set of lawyers.
Yes,
But,
P.S. Hazarika, Mrinmoy Doctor, Azad.
no one is present. Hmm?
My mother, 16. 16 is also there, my lord. Can I
16 is
take it
there?
out?
Item 16.
Pradeep Bharali. Huh? 16 is Pradeep Bharali.
Yes, sir. Lord, can you bring that immediately after vacation? Although I'm prepared, my lord.
But what is the case?
Case
My lord,
lordship in front of
302.
son, father and son are the accused persons. And in front of the son, he was a minor, your lordship. He is a witness to the incident.
I think we have heard it or something like that. No.
Lordship has not heard it.
He's a child witness, my lord. Sole child witness, my lord, turning hostile. An entire case is based on circumstantial evidence. My lord, no eyewitness. Child witness turning hostile. And he is the sole eyewitness. He was the sole eyewitness.
Who accused your lordship may take it.
But hostile doesn't mean the entire evidence is gone down the drain.
Yes, but my lord, the IO has not been contradicted. Because, my lord, the manner in which the hostile witness is to be treated is that, my lord, the IO has to be confronted again that whether that person has made a statement under 161.
And who is this child?
He is the, my lord, son of the accused.
Son of the accused, Pradeep Bharali.
Son of the accused.
Then
He
why
was also
should,
tried separately by the juvenile board and acquitted. No.
therefore, the child, this is a child witness. There is no reason why he should, implicate falsely
Yes, my lord.
his own father.
Yes.
In fact, it shows the truthfulness of the child.
But my lord, one major flaw is that, my lord, 164 statement has not been recorded after.
How does it matter? 164 is not necessary. Of whom? 164 statement of whom?
the Child also and also of the accused, because the police is saying before under
Accused,
161, they have
Accused,
confessed. My lord.
no, one, that is okay, that is okay, that's a different thing, whether he confessed or not, there is another issue. But whether child witness need not be examined under 164, just for their own, see, just to make sure that the witness does not deviate later on, normally it is adopted 164, but it's not requirement of law.
But no, one thing is, that the evidence of the hostile witness, the child, which has been turned hostile, that evidence, the statement which has made before the police, that was not again questioned from the IO. Because, for evidence of a hostile witness to be evidence, as per them, I have Supreme Court judgments, I will place.
What? You have gone through the Supreme Court judgment?
Yes, my lord. I have given the list of
Then
cases
what
also.
is the problem then?
Okay.
You are prepared, that means you are prepared. What more is there? That's the only issue. The child has given evidence. He is an eyewitness. According to you, he turned hostile.
No.
If that is so, what is to be done? How to appreciate the evidence of a witness who turns hostile?
No. Can it be taken up after some time?
Yes, Bhuya,
Lordship. My lord,
what to do? Tell us.
After some time.
after some time. You said after some time.
After some time. Till that time, what do we do? That gap
After
between
70
now
days.
and after some time, what do we do?
3 days to 1. Lordship, but Elizabeth.
So what do we do now? You want wait for what?
My lord, I don't have some files, my lord. It is.
You have not brought the files.
It is there, my lord. After 5 minutes or minute.
The 5 minutes. And Mr. Kumar, how long he is going to take?
5 minutes.
5 minutes.
It's just on that. This matter is going on.
How do you say 5 minutes?
Such an obvious.
Then you can come.
It's going to take the whole day, your lordship.
Whole day,
In
so,
the event of the matter, item number 11 to 15 and 16, can it be taken immediately after the vacation? The top of the list, my lord.
so item number 4 means
Subur Mondal.
Subor Mondal. But you are doing Subor Mondal, no?
Yes.
So you said you would like to whole day, you'll take.
If your lordship release me at 1:15, I'll be very happy.
So the question of me releasing you doesn't, I am not detaining you. Huh? It is your case. We have not apprehended anybody.
Detained.
No, what you want to say, you tell us,
Yes,
you are
sir.
difficulty today or
We'll try to finish up before vacation. This matter.
11 to 15 and 16, can it be taken up immediately after the vacation? It may be taken up in the top of the list, my lord.
11 to,
15 and 16.
okay, that 16 is that Mr. Okay,
Does
fine.
matter?
If we take up Mr. Kaur case now, then obviously, of course, others we can't take it up.
After the vacation, then?
Yes, yes. After vacation, what about tomorrow?
Tomorrow, another matter is fixed, the fall matter.
Which one?
March cut matter.
Mazghat is there tomorrow.
Mr. Ahmed, Mr. Tiaul Kamar, they long.
Tomorrow is Tuesday. Then day after tomorrow is Wednesday. And what about Wednesday? Because we have a peculiar problem here because last week is supposed to be motion day.
Yes.
But there are very few motion in this bench. Therefore, we thought that we can utilize the time by hearing the old matters. That is the only reason.
This matter will take time, Mother. I think.
This one.
Yes. It will take time, my lord.
Then we can continue
Yes,
tomorrow
yes.
also.
Yes. I'll try to finish up before vacation online.
But you said 1:30 will try to, again you are saying before vacation.
Habits have become bad during this corona time, pandemic time.
So what we'll do is that. Now this is item number
Number is 4.
4. So we'll continue hearing this 4. If he finishes, then others will not fix any date. Let it remain because you are already
My
prepared.
problem is that from tomorrow I may not be available. I am not available, lordship.
Why? You want to go, you want to start your holiday earlier
Can't-
before us?
Then there must be an injunction.
Lordship, the problem, kindly accommodate me, 11 to 15 and 16, only these matters. Or I'm, lordship, my, she's not keeping well, that's why my
Who is not keeping well?
other friend. I don't want to pressurize her.
Well, let us start, my lord. I think she can.
Vacation?
Minor.
Yes.
Item Number 12, minor. That has been already substantially hard, minor. So our part is already that concluded.
Nirma Dutta on the last occasion, last week, he said they have to like, they have to make some more submissions.
That is regarding that, item number 12 is regarding,
That, my lord,
But 11 to
one
15,
that murder took place, my lord, he was
Cattle theft.
cattle theft, my lord, buffaloes. That ultimately, my lord, mob attack. That was, my lord, the case. So that is, my lord, at length, that was hard, my lord. If anything left, my lord, from our side, it is concluded. Only, my lord, my.
only you have to
Yes.
submit.
My doctor met him last week, lordship, he said he is to make some more submission. I am ready, your lordship, with citations
The
and all.
problem is, see, around 16 matters, if you stretch for a long time, then the problem will arise.
Lordship, then his matter may be taken up as the first item, since they will be available in the coming days.
And
So let
subject
us-
to her convenience, my lord.
Please do like this, see, otherwise we won't have any matter work to do. So we'll hear today cause, we'll see, we'll try to accommodate. You see, today we are hearing Mr. Kaur,
Yes.
who is in serial number 4.
4, right, my.
So by that, see, being in serial number 4, he will be entitled to be the president, he will be
Yes, yes.
certain precedents.
Yes, my lord.
So we'll hear him.
Yes.
But he started off late. They'll get precedence because.
Oh,
their
because they had,
matters are
okay,
fixed.
okay, because they had started
Yes,
earlier.
Yes, ma'am, for my lord, for 3 or 4 days, lordship has had at length. So my lord, your lordship may, again, my lord, it will be my lord.
No, there is a problem, no, because see, once a matter is
Yes.
adjourned for a
Yes,
long
yes.
period,
My lord will.
it will take
we
some
also
time
forget,
for to recollect also, no,
Yes,
because
yes.
see, when we hear a matter,
Same with us.
see, there are certain things in our mind,
So my lord, otherwise, my lord,
immediate and the non-immediate. The immediate thing will be registered, but there may be other things which was in the process, thought process, which keeps going.
my lord, may I suggest, my lord, can it be first item of any of the day or?
Any of the day means this before
Yes,
holiday.
yes, yes, my lord, is it?
But then Bhuya says that she won't be there from tomorrow. There's a whole problem again. Why are you going? Though it is an invasion to your privacy, but then you are the only one who is on the other side. And Jahan is said that she's not well. We can't issue an injunction not to get and not to fall ill. There is something we can't do that. Perhaps we can prevent you from departing from God.
He's better be
Huh?
taken today, my lord. Now only it can be taken up. I'm ready. He's Mr. Hajarika's matter.
My lord, with me, along with me, there are 4 other council, 4, 5 other.
But you said your side is over.
My number is over, my lord. My item number 12, and my regarding my accused person, Babul Bora, it is over, my lord. If your
But
lordship,
no, but not only Babul, but Jagdish Diori also there.
yes, yes, there are
In the
other,
same case.
other 3, 4 are there, my lord.
See, there's a whole problem, no?
Yes.
Because if there are different lawyers, different, we have to adjust to different dates.
Yes, yes,
Then somebody will be not available.
yes. Or my lord, let it come.
Any day, no.
My lord, let this matter be taken. We'll see, my lord. In the meantime. Because otherwise, my lord, my part is concluded, my lord. If lordship want me to refresh something, I can do that.
No, there is no question of doing it. There is no purpose. There is no.
Yes,
It
yes.
doesn't make any sense.
Yes,
If the other lawyers are not
Yes.
there again, the same thing.
yes.
Hmm?
Well, I'll try to contact the other lawyers also. So if time remains, my lord, let us see if it will be taken up, my lord, today.
Hmm.
Otherwise, no, my lord. Because this matter may take time, my lord, what I feel, my lord.
In my case, once I analyze the evidence, then there will be nothing much more to argue. Because I am analyzing the evidence and giving my argument at the same time, whether this will be applicable or not. Because I will go on that way.
Hmm.
My lord, let this matter, my lord, continue, start, my lord. Let us see, my lord.
Okay, we'll continue, Mr. Kumar. Then we'll see after that. But then, see, if you don't complete today, then this Bhuya say that I will not be there from tomorrow. Then what do you do then?
Then I'll continue till 1:15. From 2, let them continue.
And what is the
I'm
this
there
sing-
till my end of the vacation. For me,
and-
I have no
eh?
plans.
After rising of DB.
How many single bench matters are there?
Around 15 of them, I think. There's a supply also.
Let me see the single bench matter.
Well, today let me start till 1:15. After that, from 2 they can do.
This is also hearing matter. Single bench also hearing matter. Single bench also the railway council was submitting. It has to be also concluded. Single bench will sit after rising of DB. So today it is not fixed. Huh? So it's not fixed as 3 PM or anything like that, no? So if you don't rise, then no single bench.
Proprietary will
Hmm?
recommend not to rise. People are waiting.
Because Kumar is saying that he will continue.
Well, I'll continue.
No, I
yeah,
am
we can-
correct.
Even I'll take some 1 hour or so.
Achha, you are in this case,
In some.
not Bhuya.
Item 4, she's.
In
We
4.
can
I-
again
In four.
continue tomorrow also. Well, I'm there till the vacation. I have no.
I'm here, so I can also reply whenever.
So let me begin today till 1:15.
Then in that case, what we can see, because Bhuya
She will
is,
take up his matter then.
which one?
They'll be there. Item 11 to 15.
If you are going to be tomorrow, and here this Jahan is there, so that this we can hear tomorrow also then.
Yes, no, no.
She can also go home
Ah.
and take rest.
Today you will not be because you are not feeling well today. Huh? Cough problem,
Severe,
Dangerous.
Sometimes.
cough or COVID.
Second
You have tested negative, huh? Very good.
So I'll take your lordship's leave.
Then you will continue tomorrow then
Yes,
your
yes,
case
yes.
because Jahan will be there.
Yes, yes,
And today, then we'll take it up, your case then.
Yes.
yes. I'll take your lordship's leaves.
Then for hearing list, item number 11 to 15.
Jagadish Diori, 177.
My lord, I am representing Babul Bora.
Where is the file? Where is the file?
Well,
Thank you to the public.
So my lord, my humble submission before lordship was that since in evidence, it has clearly come out that there was a mob who attacked this person. Probably this the accused person brought him to that particular place. It's true, my lord. But my lord, to attract section 302, my lord, it is not to that extent, my lord, applicable so as to attract 302 evidence on record, because no specific injury were attributed to any of the accused persons.
Okay, we'll just
Yes,
note down these
yes.
basic facts of the
Yes,
case, no?
yes.
On the present appeal.
Yes.
These, the three appeals have been taken together, namely Krill appeal number, Krill A number 177 of 2016.
My lord,
That-
5 appeals.
Five. That earlier I have dictated Mr. Doctor,
No, heard him, my lord, but not dictated.
but not it. Okay, Liko. Three appeals, Krill, appeals have been taken together. Krill appeal number 175. 1, 2, 3. We have 3 only.
The model number?
3.
11, 12,
We have only 3 appeals. This paper book is of 3.
5
Okay.
appeals, my lord.
5 appeals. Okay.
11 to 15.
The 5 appeals, these 5 appeals, namely Krill appeal number 177 of 2016, filed by Jagdish Deori, comma, Krill appeal number 329 of 2018, filed by Babul Bora, alias Bokshon, comma, Krill appeal number 7 of 2019, filed by Punaram Kurmi, comma, Krill appeal within bracket J number 89 of 2019, filed by 89 in serial number
Serial number 14, my lord.
89 by Kano Bora, alias Baba Gogoi, and Krill appeal J within bracket J number 90 of 2019, filed by Ghuron Gore, are tagged together and heard together as these appeals arise out of the same judgment rendered by page number
56, my lord.
rendered by the learned session judge Lakhimpur, and not Lakhimpur, in sessions case number 89 within bracket NL oblique 2011. Judgment dated 3/12/2014, rendered by the learned session judge Lakhimpur, not Lakhimpur, in session case number so, by which the 5 appellants have been convicted for committing the offence under section 342/323/302/34 IPC. Acquitting one of the co-accused, namely Bijoy Pagang, of the aforesaid charge. Full stop. As we proceed to examine the grounds of appeal raised in this batch of petitions, appeals, batch of appeals, it will be appropriate to advert to the basic facts and evidence which have been brought on record. Next para. The criminal justice machinery was set into motion after an FIR was lodged on 17 on 16/9/2007 by one MD Aijul Ali. The complainant was examined as PW4 in the trial to the fact that at around 1:30 PM on 15/9/2009, some persons of a nearby village called his mother Juleka Khatun, his father MD Abdul Ali, and elder brother MD Tajabur Ali from their house to the field near number 1 Pasnoy LP school, where they were tied and assaulted, leading to the death of his father Abdul Ali, MD Abdul Ali, and a grievous injury to her mother Juleka Khatun and the elder brother MD Tajabur, where they were left there. On the basis of the said complaint laws, the FIR, a police case, on the basis of the aforesaid FIR laws, the police case being North Lakhimpur Police Station case number 608/2007 under section 342/302/325/307/34 IPC was registered. Accordingly, the criminal investigation was launched. On completion of the investigation, 6 persons, including the present appellants, were charged of committing offence under section 342/34, 342/302, 323/342/302. Then you write 342/302/323/34. On being committed to the Court of Session Judge, Lakhimpur and not Lakhimpur, the accused, accordingly, six accused, including the present appellants, were charged for committing offence. The following committing offence as mentioned below. Page 7, right? Firstly, secondly, thirdly. In support of the aforesaid charges, the prosecution examined as many as 13 witnesses and also produced material documentary evidences. Stop. On completion of the recording of evidence of the witnesses, the accused appellants were examined under section 313 of the CRPC. All the accused, however, claim that they were innocent and have been falsely implicated in the present case. They also declined to lead evidence in their defense. Stop. On the basis of the evidence on record, learned session judge convicted the present appellants, present 5 appellants, under section 342/323/302/34 IPC. However, acquitted the 6th accused, namely Bijoy Pagang, and sentenced the appellants to undergo life imprisonment with fine of rupees 5,000, in default of payment of which to undergo further rigorous imprisonment for a period of 6 months. For committing the offence under section 302/34 IPC. As regards conviction under section 323/34 IPC, the present appellants have been directed to undergo simple imprisonment for a period of 3 months with a fine of what is this ID? Okay, that means so as far as these 323, they were not sentenced, they were only fined. No, the sentence to pay a fine.
They were only sentenced.
Sentence, no. Okay, they were, 323, they were sentenced to pay a fine of rupees 1,000 only, in default of which to undergo simple imprisonment for 3 months. Similarly, in respect to offence, in respect to conviction under offence under section 342/34 IPC, they were also sentenced to pay a fine of rupees 1,000, in default of which to undergo simple imprisonment for 3 months. So stop. As we proceed to examine the appeal, we'll refer to briefly advert to the evidence which have been brought on record. The first witness examined by the prosecution was Srimati Dulomani Datta. Who identified the accused in the dock He was managing the fair price shop, which was run by her husband, and located adjacent to their residence. She stated that the occurrence took place about 2 years ago at about 7 p.m. when she was in the shop. The police came there and asked for a lamp And accordingly, she and her husband came out with a lamp, whereupon the police took them to a nearby place where they found the dead body of a person lying more than 100 feet away from their shop. They also saw the mother of the deceased the mother and son of the deceased sitting there. She, however, stated that she had no knowledge under what circumstances the death occurred and the body was found lying there. In a cross-examination, she stated that she heard people shouting at a time of occurrence and several villagers a number of people from several villages had come to the place of occurrence. And she heard from the villagers that the deceased had committed theft of 6 buffaloes prior to the occurrence. She also stated on one occasion earlier, the villagers had recovered 4 stolen cows from his possession. Next paragraph. The next witness examined was Musammad Jaleka Khatun. She is the wife of the deceased Abdul Ali and mother of the Tajpur Islam who was injured. She deposed that the occurrence took place on 15/8/2007 at around 1 p.m. On the day of occurrence, she and her husband and her son Tajbur were sitting in the courtyard of their house when the accused Punaram Kurmi, Babul Bora alias Bhakshan, Kanu Gogoi, Jagadish Diori and some other persons entered their courtyard and dragged her husband to the house of one Ramesh Kurmi, alias Boharia. She stated at that time she did not see Bijoy Pagang with the accused persons. Those persons then took her and her son Tajbur with them, and thereafter they were assaulted with dao lathi. They were then taken, all the 3 of them were taken to village Pasnoy, where the accused persons assaulted her husband, her son with lathi, as a result of which her husband died at a spot and her son Tadabur sustained serious injuries on his person. She stated thereafter Punaram Kurmi, Gura Gor, Jagadish Diori and Durga Kurmi and Bogai Gor, who absconded accused Durga Kurmi and the Bogai Gor guarded the dead body of her husband and her son, her injured son, while the other accused fled from there. She stated that she remained at the place of occurrence till the morning the next day. And at about 10 a.m., her daughter-in-law, the wife of another son, Aijul, arrived at the place of occurrence and accordingly reported the same to her father, who informed the police about the occurrence. The police thereafter arrived and took them to the hospital for treatment. She stated that the police got the statement of his son, Tadabu, recorded in the court of judicial magistrate. In the cross-examination, she stated that accused Bijoy Pagang was not involved in the occurrence in any manner. She also stated that police that her statement was recorded before her statement was recorded by the judicial magistrate on being produced by the police. She was subjected to a detailed cross-examination and denied the suggestions made by the defense. Next paragraph. The next witness examined was MD Tadabur Islam, the injured son mentioned above. He also more or less stated deposed in similar line as deposed by PW2, his mother. He, however, in his deposition mentioned the name of Babul Bora, alias Bhakshan, who had struck him with dowel on his right leg near the knee. However, he also mentioned that the accused Bijoy Pagang was not at the scene at the time of occurrence. In the cross-examination, he admitted knowing the identity of the accused persons. He also admitted that he did not name these accused persons when his statement was recorded by the judicial magistrate. No of those persons who had dragged them away from their courtyard to the house of Ramesh Kurmi. However, he denied the suggestion made by the defense that his father was involved in theft of cows, buffaloes. And he claimed that the buffaloes recovered belonged to their village. Next witness examined was Aijul Ali as PW4. He could identify only two accused, namely Baksan and the Gurum Gor, by name, whereas in respect of the remaining four accused, he stated though he knew them by face but did not know by their name. He is the other son of the deceased Abdul Ali. who lodged a complaint. He was an eyewitness inasmuch as he stated he was in a place near Zero, Z-E-R-O, in Arunachal Pradesh on the day of occurrence, and he came on being informed telephonically by his wife. That his father, mother, and elder brother were taken forcibly by some persons from their house. He lodged the FIR on the next day after getting information. Next period. The next witness examined was Dilip Dotto. Who was a member of the Dizu Gaon Panchayat. He stated that on the day of occurrence at about 10 p.m. when he arrived his house, he learned from his wife that about 200 to 250 persons had taken away the deceased Abdul Ali, Juleka Khatun and Tazabul Islam on the allegation that they had committed theft of bullocks and cow in the village. And on the next day at around 12 noon, he heard that Abdul Ali had died near LP school of number 1 Pachoni Gaon due to injuries sustained. And accordingly, he went to see the dead body, where he also found Jaleka Khatun and Tazbul near the dead body. He stated at about 6 p.m. on the same day, the police arrived. The police also conducted inquest on the dead body of deceased. In the cross-examination, he stated that when he asked Jalekha Khatun as to about the occurrence, she told him that about 200 to 50 persons had assaulted them. So next para. The next witness examined was MD Hassan Ali as PW6. He was an eyewitness. He came to know about incident after being informed. And thereafter went to the place of occurrence where he found Abdul Ali lying dead at the place of occurrence. When the place of occurrence, he found Abdul Ali dead there, and also found Juleka Khatun and Tazbur Ali sitting there with injuries on their persons. Next. The next witness examined was Srimati Dipali Kolita as PW7. She stated that on the day of occurrence, when she went to the shop of her elder brother, Dilip Dotto, at around 6:30 p.m., she found a dead body lying near the LP school situated at number 1 Ujani Pansnoi. And there she also found the wife of the deceased and son sitting there. And later on, the police arrived there and recorded her statement. In a cross-examination, she stated on the day of occurrence, she had learned from villagers that a thief had been killed and she did not find any injury mark on the wife and son of the deceased. Though she claimed that she did not know how the deceased died. Next, the next witness examined was Srimati Arati Gowla. She also stated at the time of occurrence, she saw many people, including the accused persons, at the place of occurrence. And she saw many people assaulting Abdul Ali on a charge of theft. She also mentioned of the presence of Tazbur Islam and Musammad Juleka Khatun at a place of occurrence. However, she stated that she had not seen people assaulting Tazbur and Juleka. She stated that on the next day of occurrence, she came to know that the said Abdul Ali had died because of the assault. Though she herself did not see the accused physically assaulting the deceased at the time of occurrence. She denied, in the cross-examination, she denied having stated before the IO that she had seen the accused in a gathering The next witness examined was Srimati Pooja Kurmi, who stated on the day of occurrence at about 3 p.m. the villagers had apprehended Abdul Ali, Azizul Ali, Tajabur Islam and Juleka Khatun in connection with the theft case. And they were taken to number 1 Pashnoi village and subjected to assault. And they were assaulted. And she came to know the next day that Abdul Ali had died. However, she stated that she did not see any of the accused persons standing in a dock among the villagers who took the deceased Abdul Ali and injured Tadabur and Jeleka to the school, at the said number 1 Pashnoi village school, to number 1 Pashnoi village. The doctor who examined the injured Juleka Khatun and the MD Tadabur Islam was Dr. Tulsi Prasad, was examined as PW10. Who found the injuries, who found the following injuries on the body of Tajabur Islam, page 29. Simple injuries. And also the following injuries on the body of Juleka Khatun. And as per the said doctor, the injuries were simple and caused by blunt object. In a cross-examination, he also stated that these injuries could be caused due to fall on hard substance. The next witness examined was Anil Kumar Basfor as PW 11, who was a magistrate before whom statements of MD Tadabur Islam was recorded under section 164 CRPC, as well as of Jaleka Khatun, wife of the deceased. The next witness examined was Dr. Paul Koa Dury as PW 12, who conducted a post-mortem examination of the dead body of Abdul Ali, and he found the following injuries on the body. Page 33, lacerated. And according to him, the cause of death was due to shock as a result of head injury sustained by the deceased. And these injuries are sufficient to cause death of a person in ordinary course. There was no cross-examination of the said witness. The next witness examined was S.I. Badiul Haq, SPW 13, who was the IO of the case. He stated that one DVD secretary, MD Abdul Matlab, had informed him over telephone that a thief was severely assaulted by a mob, causing his death in the field of number 1 Pachnoy LP school. On getting the information, a general diary entry was made, being GD number 238 dated 16/9/2007, and informed the officer in charge of the North Lakhimpur police station. Later, the Ejhar was lodged. He carried out an investigation. He also conducted, as part of the investigation, he conducted inquest. As part of the investigation, the inquest was conducted by the executive magistrate in his presence, which was then referred, the dead body was referred to the North Lakhimpur Civil Hospital for post-mortem examination, and the other two injured, namely Musammad Jaleka Khatun and the MD Tajibar Ali, were sent to the hospital for their treatment. He stated that while he recorded a statement of the accused, two accused, namely Sri Bijoy Pagang and Durga Purbi, and Bogai Gaur, could not be arrested. They were evading arrest. Further reference to his evidence will be made at a time of consideration of the submissions of the appellants. Next para. We have also gone through the statements of the accused recorded under section 313. However, as mentioned above, they claim innocent and stated they have been falsely implicated. Stop. You are in item number? 12. Mr. T.H. Hazarika, Lana Council, appearing for the appellant Babul Bora, alias Bokson, in Krill Appeal 329 of 2018, submits that. So briefly, what is your submission number 1?
Submission number 1 is my lord.
Yes.
302, it needs to be, my lord, beyond reasonable doubt. The evidence against me has to be
Okay.
specific and beyond reasonable doubt. That is not in this case.
Okay.
As my lord, because assault was by on evidence, my lord, by around 200 to 250%. So if no specific injury is attributed to any person, my lord, it cannot be held beyond reasonable doubt that I have caused the death.
Okay. Then
That is my point.
then
And my lord, and second line would be, my lord, that if any of the part of the assault is proved against me, my lord, it would be at best 325. Because no sharp weapons were used. It was all are blunt weapons, my lord. For that, my lord, if I concede, my lord, if there is any, that would have been under 324. Since, my lord, it doesn't fall in, probably it doesn't fall into any of the exceptions of 300 and 300, my lord. So 302 has to be proved in this case, my lord. All the ingredients of 302, that has not been proven in this case.
Yes, then then third point, that's all 2 points, basically 2
Yes,
points.
2 points, my lord.
IPC and CRPC. Mr. T. Hazarkar
And,
Lane.
my lord, lastly, my lord,
Yes,
164 statements
yes.
against me, that cannot be that should not be considered my prayer, my lord, because of the fact that 164 statements were not exhibited by the person who have stated those statements, because for that reason defense would not, my lord, open its card, because to implicate itself, my lord.
Correct. Okay, that's all. Okay, Mr. T. H. Hazarkar Lane Council, Lane Appellant, Lane Council for the Appellant, Sri Babul Bora, alias Boxon, submits that in view of the evidence which have come up in course of the trial through the mouth of the witnesses, nothing has been specifically mentioned about the role played by the appellant in causing the death of the Abdul Aziz. In such an event, conviction of the appellant by the Lane trial court under section 302 IPC cannot be sustained. It has been submitted that in order to convict any accused under section 302 IPC, section 2 IPC, there must be cogent evidence to show the actual role played by the accused in causing the death of a person. In the present case, no eyewitness has mentioned of any specific role played by Babul Bora in causing the death of the deceased. And as such, and further, on the contrary, there is evidence to the effect that there have been a large mob which has gathered
Actively
at a place, about large mob, about 200 to 250 people gathered at a place of occurrence where allegedly seen to have assaulted the deceased and the 2 injured persons.
Yes.
But the specific role played by the appellant from amongst the said large gathering of mob has not come out clearly in the evidence.
Yes.
Under such circumstances, it would not be appropriate for a trial court to convict the petitioner appellant under section 302 IPC. At best, it can be.
Yes. Yes.
At best, if the presence of the accused of the appellant is considered to be established, at best, he can be convicted under section 325
of the IPC.
5 of the IPC. It has been submitted that the use of any sharp weapon has not been established. The post-mortem report, page number,
Postmortem.
Post-mortem report, no, 92. Post-mortem 92.
PM report at 92.
It has been submitted at the post-mortem report does not mention that the injuries caused on the deceased were by use of any sharp weapon.
Yes. As there were no inside injury is not present. All lacerated.
though the cause of death was due to the head injury sustained by the deceased. The head injury was not. What is the head injury? Please.
The injury, my lord, that
It is not been shown that the said head injury was caused by any sharp weapon.
or by the accused.
Huh?
Or by Babul Bora, my lord.
Or by the present appellant Babul Bora. Further, the learned trial court also relied on the statement recorded under section 164 CRPC of the witnesses PW
2 and 3.
2 and 3. However, in which the appellant was implicated.
Yes.
However, that statement was never exhibited
By the PW
by the PW
2 and 3.
2 and 3, and as such cannot be said to have been proved.
My lord, my submission was that since PW 2 and 3 has not exhibited it, what implicated me, I will not bring on record, my lord. Defense will not bring it on record.
Full stop.
So properly,
Since the said statement recorded under 164 CRPC were not exhibited, the accused appellant had no obligation to refer to the said statement recorded under 164 CRPC,
to contradict the same.
which would implicate the appellant for the purpose of contradiction under section 164, huh?
Yeah, 164, my lord.
164 of the Evidence Act. 164, 164, 145, sorry, 145 the Evidence Act.
145. One
145 the Evidence Act.
My lord, later on it was exhibited by the magistrate, but while cross-examining 2 and 3, my lord,
It has been submitted, though the said statement of the PW 3 and 4, 4 and 5. And we'll see in the judgment. Though the said statements of the PW 4, 2 and 4,
2 and 3.
2 and 3, recorded under 164 CRPC were produced by the magistrate who recorded the statement
Yes,
within bracket PW
7.
7. Since the statements were not made by the magistrate but merely a recorder, the said statements could not be used for the purpose of cross-examination
Yes,
to discredit the
precisely,
evidence of PW 2 and 3.
precisely. That is the case.
And as such, under such circumstances, such incriminating evidence is contained in the statement recorded under 167 could not be used by the learned trial court against the petitioner, appellant. That's all.
Yes, that's all, man.
Yes, who is the other appellant? Who is the other? Yes, Mr. You are for whom? Mr. Dotto. Okay, you are Michael. Yes.
Yes, madam.
Yes, what is your submission?
My submission will be very similar, of course, my lord, some differences there.
Yes.
First submission is that, my lord, no injury has been attributed to me. First of all, that I had caused the injuries. My lord, lordship will see the evidence of PW 8 and 9. PW and 8 and 9 were eyewitnesses. They said that they did not see us assaulting the persons. And my lord, so far as the PW 2 and 3 are concerned, PW 2 has said that they were, the Gorangor, the appellant was guarding the deceased person after the assault took place. But there is no statement that he was a part of the assault battery or assault gang. Then, my lord, the next submission would be that there was no sharp weapons used. So therefore, it was since it was a mob violence, and even if these persons were there as a part of the mob, there was no intention to kill. Though it is stated that dows, etc., were being carried, but there is nothing on record to show that there was any dow being used, because the weapons, the injuries are lacerated injuries, no sharp injuries are there. So the dow was not at all used. Even assuming for a moment that dow was being carried, there was not used. So therefore, there was no intention to kill. And therefore, 302 cannot be expected.
Yes.
And since it's a mob violence, unless there is something specifically attributed, then one has to fall back whether there is a meeting of minds of all these persons to kill this person. There was no such meeting of mind, because no sharp weapon was used. There is no evidence of any sharp weapon being used. Even if it was there, someone was carrying that weapon, no one had used it. Secondly, if your lordship will find, well, there is some inconsistency in the story where actually the dead body was found. They were trying, the PW 2 and 3 were trying to say that they had gone into some jungle and where the bodies were recovered.
PW
2 and 3 in their 164 statements had said before the court, so police, that
you are using 164 statement. Are you going to use 164 statement?
Well, in their case was that these bodies were recovered somewhere from the jungle, my lord. In fact, my lord.
So you want to use 164 statement?
My lord, I'll try to draw a distinction here, because in their evidences, my lord, they have not very clear. They say that their bodies
so
were.
You want to take advantage of 164
yes,
statement?
Yes, ma'am.
Okay.
Yes, ma'am.
So what do they say of 2 and 6?
My lord, 2 and 6, my lord, they say, my lord.
In their let us see their statement 164 statement.
Yes.
Please.
My lord, page 88, my lord, is that of Juleka Khatun, my lord.
Page 88.
Yes, my lord. So it appears, my lord, there is something beyond, my lord, something more than what had happened. And in that particular night, there was something more than what, my lord, happened in the evening, my lord.
Jaleka Khatun.
Yes, my lord.
And your name is Guran, no?
Guran, my lord.
Guran. Your name is mentioned here.
My lord.
Punaram, Boxon, Guran. Your name is
yes,
number 3.
Yes, my lord.
Number 3. Your name is number 3. Enter house, drag husband. Started beating with lathi without rhyme and reason.
Yes, that was 164. That was there.
They assaulted till 4 p.m. Accused Boxon for injury. Boxon is mentioned. At last, Boxon, I don't know, strangulated. Panchet Kanu Gogoi, while I was witnessing one of the accused, dealt a heavy blow on my head with a lathi, where I became unconscious.
Later,
no, what is there? I fetched.
Well, around 5 p.m. I found myself lying in a jungle at another place about 2 kilometers away from the place of occurrence. But the body, as it has been recovered with the police, is from the place of occurrence and near the school, nowhere in the jungle. So, well, there is inconsistency as to whether the body was actually recovered from then she said that I found my husband lying there in unconscious state. Though I had fetched water from the nearby ditch and poured the same on the mouth of my husband, he did not open his eyes. Thereafter, I found my son too lying in the injured state and the accused person surrounding us with their lathis in their hands.
Apart from this inconsistency, any other?
Well, so what I'm trying to say, is there is inconsistency with regard to the place where the body was found, and in the in a statement before the court, in the trial, she did not say that these persons were part of the assault battery. She only said that they were guarding, Lordship will find it page 12.
In guarding.
Yes, page 13. Gorangara, page 13, first line.
Page 20.
Yes, my lord.
PW?
PW2, my lord.
2, guarding.
Yes. After the physical assault, accused persons so-and-so, Goran Gora, Jagdish Deori and other absconded accused, Durga Kurmi and Bogai Gora guarded the dead body.
Yes,
of my
after
husband.
assaulting.
Well, it doesn't, so far as the other persons are concerned, where they here, my lord,
You beat them, then
Right.
you guarded their bodies.
the lordship will see, my lord.
So what is?
So where we guarding? Where we guarding, near in the school or in the jungle, my lord? So there is total inconsistency in the, my lord, statements, my lord. If there is a jungle, who took the body to the jungle, my lord? All
Anyway,
these things, inconsistencies
okay.
are there, my lord.
Then
Then, my lord, lordship will see, my lord, the incident, if your lordship looks at the incident, my lord, has three parts, my lord. And the investigation was basically carried out with in the place of occurrence.
yes,
Because, my lord, I'm saying has three parts.
yes,
First of all, my lord, there is a case of dragging the victims from the house
yes,
to the residence of one Ramesh Kurmi, where some assault takes place.
yes,
Then, my lord, they were supposed to be taken to, my lord, Pasno village.
yes,
So the incidents are with three parts, my lord. One,
yes,
dragging the victims from their house to the house of Ramesh Kurmi. My lord, so dragging is one part of the incident.
yes.
Second part of the incident, some assault takes place in the house of Ramesh Kurmi. That is the prosecution story. And the third part is at Pasno village, my lord.
Yes.
Now there is a big mob also involved, which, my lord, comes out from the records, from the evidences. So therefore, my lord, there is total, my lord, there is nothing very, my lord, concrete as to who were actually part of this mob in the various places. Even if they were, my lord, assumed that they had dragged them out of the house, whether they were actually the persons who assaulted them at, my lord, Pasno village is unknown, my lord. And rather, my lord, at Pasno village, respondent, sorry, my lord, the PW number 8 and 9, they were supposed to be eyewitness, my lord. They said that the accused were not seen, my lord, assaulting. Lordship will find that, my lord, accused number 8 and 9.
Page
8 and 9, lordship will find that page. 8 and 9. Yes, 8, my lord, page 26.
Page 20.
26, my lord. My lord, she is apparently an eyewitness. The occurrence took place about 5 years back. At the time of occurrence, I saw many people, including the accused, at the place of occurrence. So she saw the accused. At the time, many people assaulted Abdul Ali on the charge of theft. Injured so-and-so and so-and-so were also present. I have not seen people assaulting Tajabur and Juleka. On the next day of occurrence, I came to know that Abdul Ali died as a result of the assault on their person. I had not seen the accused physically assaulting the deceased Abdul Ali at the time of occurrence. So what I'm trying to distinguish, your lordship, is that even if they were involved in dragging this person out or bringing to the house of Ramesh Kurmi, they were not seen assaulting the person's, my lord.
Okay, very
Pasno.
8 and 9 say
8
the
and
same thing.
Same thing. My lord.
Okay.
So therefore, my lord, the incident took place at various installments, or, my lord, and there are several events, my lord, chain of events. And, my lord, the prosecution did not even try to establish, my lord, who were there at what point of time, and, my lord, how this entire incident took place.
Okay.
So therefore, who actually killed this person who caused the head injury, my lord, is, my lord, a question, my lord, which is in realm of doubt, my lord.
Okay.
And, my lord, as I have already stated, my lord, the weapons used were not of such nature, my lord, that not indicating that there was an intention to kill. Now, so far the lathi is concerned, my lord, there is nothing on record to show, my lord, that the lathi was actually used for the head injury caused. And, my lord, the prosecution, lathi, my lord, is a very, very common word, my lord, used, my lord. It can be a lathi of a, my lord, very slick lathi also, my lord. It can be a very strong, my lord, bamboo kind of a lathi, my lord. So the prosecution even didn't try to establish what kind of lathi was being used. Or what I'm trying to say, my lord, is that the head injury that took place, my lord, and which is supposed to be the death, cause of the death, my lord, there was no external injuries, my lord, no external marks. So, my lord, use the head.
Lathi.
Yes.
Let us see the head injury. Page.
Head injury, my lord, 92, my lord. '93, my lord. Skull, vertebrae. No injury sign.
Brain and spinal cord.
Yes, my lord.
Hematoma.
Hematoma. Hematoma that is there.
over, hematoma over the left temporal.
Temporal vulval.
Uh,
What I'm submitting, my lord, this injury is, my lord. My lord, had it been a weapon, the weapon used being of a heavy nature, my lord, even the lucky would have been heavy, my lord, then there would have been some mark, my lord, injury mark outside, my lord. Some, my lord, fracture in the skull, some kind of, my lord, injury, my lord. There's nothing of that sort, my lord. What I'm trying to, my lord, submit is that, my lord, the so-called used weapons or used for the purpose of, my lord, beating them up, my lord. They were not intended to kill, my lord. That is my basic contention, my lord, that the weapons used were not even intended to kill the persons, maybe to teach them a lesson. To that part, perhaps there might be some, my lord, evidences on record. But that actually, my lord, a group formed, my lord, to kill these persons, they had prior meeting of mind or even a meeting of mind at the place of occurrence, my lord, that is nowhere established. Since no specific injury has been, my lord, attributed to anyone, my lord, so if they are to be implicated by in a group, my lord, as a part of that mob which caused the death, my lord, there is nothing to show that there was intention to kill, my lord. Either at the time of, my lord, when they met together, my lord, to drag these people out, or when the assault took place, my lord. And, my lord, what I was trying to, since I was trying to say, my lord, that there are 3 instances or 3, my lord, places where this occurrences took place, my lord. It does not been, my lord, proved as to where the actual assault took place, which resulted in the death, my lord.
okay.
So, my lord, these are the inconsistencies which are there, my lord.
Yes.
And, my lord, so far as, my lord, this another part, my lord, the accused was absconding, my lord.
Who
Is
are the
Vijay Pagag, my lord. He has been, my lord, given a clean sheet by the PW2 and 3. But, my lord, what was the reason why he's absconding, my lord? It's very, my lord, it appears that he had no other reason to, my lord, abscond, my lord.
Except for after realizing that he has committed a crime.
Maybe, my lord, because
You want to shift the.
no, as I was trying to say, my lord, that the incident took place at various installments, my lord. Some people dragged him out of the house. Some people, my lord, assaulted him in the house of Ramesh Kurmi, my lord. And then the final assault perhaps took place at the house of near Pasno village. My lord, this Vijay Pagag is a resident of Pasno village, my lord. The police has charge sheeted him.
But you say you don't know nothing about the incident. Why are you submitting this? You say, I don't know anything. What has happened? These are all false cases.
No, well,
You don't know anything.
no, I'm talking the evidence.
Then why you bringing Vijay
No,
Pagag?
no, I'm talking of the evidences on record, man. That's what I'm saying from the evidences record. I'm not saying on what I know, my lord. I'm saying from the evidences on record, there is nothing to show, my lord, that we had killed these persons. So therefore, my humble submission is, my lord.
So according to this, since Vijay Pagag had absconded, he remained absconding or what? He's still.
Still, of course, we cannot say, my lord. In the trial, he was absconding, my lord. Huh? No, because my lord, he was absconding, because, my lord,
He remained absconding
my lord,
in a trial throughout the trial. Okay.
PWM 2 and 3, my lord, say that he was not involved. So therefore, he was acquitted, my lord.
Under 2, Bojai and Mika was absconding, my lord.
But then who was acquitted by the trial court? Who was acquitted?
Vijay Pagag.
Vijay Pagag was acquitted.
He acquitted because, my lord, the PW 2 and 3, they said that he was not involved in the incident.
He may be a very person who doesn't have very strong so every little bits, danger he runs away. Doesn't mean that he's
Or maybe he is such an influential person, my lord, he had asked them, don't take my name. Quite possible, my lord.
and the PW 8 and 9, he was not involved.
But PW 8 and 9 has specifically, my lord, said with the
Yes.
agency as well.
Yes. Then anything else?
My lord, so therefore, my humble submission, my lord,
Okay.
this is a case, my lord, where there was a group violence, my lord. And since no, my lord, specific injury has been attributed to the Gurangora, my lord, whether he was a part of that mob, my lord, with the intention to kill, my lord, that is not been established. So therefore, my lord, there is no intention to kill, my lord. Even if there is some intention of dragging out, my lord, teaching them some lesson by beating them, my lord, there's no intention to kill, my lord. So therefore, 302 is not affected at all, my lord. Therefore, my lord, and since they have already served 7 years and all, my lord, so therefore, my lord, at this stage, my lord, they should be, my lord, my case would be for an acquittal, my lord, because nothing has been shown that they were part of the incident or part of the move, my lord, group, my lord, who wanted to kill this person with the intention to kill, my lord. And that intention is neither, my lord, attributable, my lord, when they gathered, nor, my lord, at the time when the assault took place, my lord.
Okay. Mr. Mrinmoy Dr. Lanet Amicus, appearing for appellant Kanobora, alias Baba Gogoi. Gurun Gaur, in Krill appeal within bracket J90 of 2019 submits in similar line, has endorsed while endorsing the submission advanced earlier by Mr. H.A. Hazarika submits that from the evidence, it appears that there was a mob violence consisting about more than 200 people. And no specific role has been assigned to the present appellant, having caused any specific injury on the body of the deceased. In fact, he has been given a clean sheet by PW8 and PW9, who in their statement, yes, page number.
It's 26.
Page-
26 and 20, yes, 26 and
Who had stated that they had not seen the accused physically assaulting the deceased Abdul Ali at the time of occurrence. Thus, the said two eyewitnesses PW8 and 9 examined by the prosecution to support the case, when they themselves had stated that the accused, that they had not seen the accused physically assaulting the deceased, the question of conviction does not arise. Further, as far as PW2, who is the PW2, the injured witness, namely Jalika Khatun is concerned, she also stated that she also did not assign any specific act to the appellant Gurun Gaur of causing for a specific role in causing, in assaulting, while assaulting the deceased, though apart from making a general statement that the accused and others had assaulted, had dragged them from their house to the house of Ramesh Kurmi and thereafter to the school. The said PW2, however, mentions that the present appellant and Jagdish Dori, present appellant, Jagdish Dori, other accused Jagdish Dori, Durga Kurmi and Bogai Gaur were guarding the dead body of the husband. And her injured son, but the said witness did not specifically say that it was the appellant who caused the fatal blow on the head, which ultimately led to his death. It has been also submitted that from the evidence, though there is a reference to use of dao, a sharp weapon, but that such a sharp weapon was actually used is not borne by record. Learned counsel, learned amicus, referring to the postmortem report at page number postmortem
95.
95.
93,
93 submits that there was no injury sign on the skull and vertebrae, though in the brain, in respect of a brain and spinal cord, there is a finding of hematoma within bracket blood clotted over the left temporoparietal region within bracket subdural. Thus, the said injury mentioned in the postmortem report does not indicate use of any sharp weapon. It has been further submitted that there is also not an indication that any lathi which has been allegedly used also was used, or if the lathi had been used, it would have caused certain laceration, injuries, lacerated injuries over the
Or marks.
marks over the skull or the head, which is also not indicated. Further, it has been submitted that establishment of intention is necessary to convict anyone under section 302
With 34 man.
with 34. However, nothing has been brought on record to show that the accused had in association with others, had conspired to kill the deceased. Since it is a mob which had apparently assaulted the deceased and other two injured persons, it cannot be said that the intention to kill has been established.
On part of the accused, my lord.
On the part of the accused. Nothing has been shown about the meeting of mind of the accused to cause death, to cause the murder, to cause death, to cause the death of the to cause death of the deceased intentionally. Since the evidence shows that it was a mob violence, without any specific role assigned to the accused as part of the mob, they could not be picked up for convicting them under section 302 IPC. They have been submitted apart from the aforesaid deficiencies in the prosecution case. There are inconsistencies in the evidence of the witnesses. Referring to the statement of the PW2 and PW3, in the statement recorded under 164 CRPC, Learned Counsel for the Appeal submits that from the said statement, it appears that the dead body was found in a jungle, which does not appear to have been, which is not the case when the witnesses deposed during the trial. All the witnesses stated that the dead body was found near the school, and there is no reference to any jungle. It has been further submitted that the prime witnesses, that is the injured witnesses, had categorically stated that they were first dragged from their house to the house of one Ramesh Kurmi, where they were assaulted, and thereafter they were again taken to Pasnoi village, where they were again subject to assault, where the deceased ultimately died. Thus, from the prosecution, from the evidence of PW2 and PW3, the incident occurred in different stages, in different phases. First, the abduction; second, the assault, the abduction; the second, assault in two places. However, these had not been corroborated by other eyewitness account. All the other remaining eyewitness account mention of the assault by a mob of the deceased and injured in the school. And on the contrary, PW8 and PW9 had the two eyewitnesses had categorically stated that the present appellant and other accused were not in the place of occurrence.
No, not seen.
Not seen
Not
in the
seen
place,
assaulting.
not seen in the place of occurrence.
Not seen assaulting.
Not seen assaulting,
Not seen.
assaulting the deceased. It has been also submitted that Bijoy Pagang, who is one of the accused, had remained absconding. And as to the role of the said Bijoy Pagang has not been established. As a role played by the said Bijoy Pagang has not been mentioned by the prosecution. In other words, though the said Bijoy Pagang had remained absconding, the prosecution has not been able to clearly apportion the specific role played by each of the individuals, including the present appellant, in causing the death of the deceased. I think these are the some and economy it has been submitted that it can be said that the prosecution has been able to prove the case against the appellant beyond reasonable doubt. We will continue after that. Who will be submitting? Mr. Dotto is there.
Yes.
Is that there? Then Mr. Hazarika has completed. Then what about Mr. Jagdish Diori? You're there, huh? Jagdish Diori. Okay, then we'll continue after that. We'll finish it up.
Yes.
I think we can finish it up today.
Yes.
We are more or less the same thing. There is nothing.
Again.
Huh?
More or less it is again.
Same. I think more or less. There is nothing because we have gone through the evidence.
Of all the witnesses, PW, this case primarily raised on the witnesses of the two main witnesses, PW 2 and 3. PW 2 and 3 are
Yes.
interested witnesses. That would be my first submission.
Yes.
Secondly, as far as this case is concerned, either from the statement of the witness recorded under section 164 or the evidence, nothing has come up on record regarding the role played by my accused as to the commission of offense. There is no meeting of mind. There was no intention to cause that. From all the prosecution witnesses, it has come to the fore that it was a case of mob violence. There was no meeting of mind. More than 200 persons had assembled in a particular place and some injury had taken place. There was no intention to commit murder or homicide in any manner. So other than that, Lordship, if Lordship comes to the evidence of PW2, another thing that there are two informants in this case. One was Aijul Ali, who lost this FIR. And as per the own version of the injured witness, PW Jaleka Khatun, PW2, Jaleka Khatun says that my daughter-in-law, Joshnara Begum, later on I came to know from my daughter-in-law, Joshnara Begum, that her father Hassan Ali lost the FIR about the occurrence. If Hassan Ali had indeed lost the FIR, then where is that statement or the evidence of Hassan Ali? There has to be two FIR in this case. Whether that FIR was treated as a 161 statement, because subsequent FIRs, Lordship also knows that has to be treated as statement of witnesses under section 161.
Yes.
So this particular person, Hassan Ali, was not made a witness, nor his statement was recorded before the court.
This PW This.
PW2.
No, this Jalika Khatun.
Yes, yes. Jalika Khatun says in the later part of his evidence
Hmm.
that later on I came to know from my daughter-in-law, Josnara Begum, that her father Hassan Ali lodged FIR about the occurrence. But this Hassan Ali was not made as a witness in this case, nor the statement or GD entry to that effect was ever exhibited before the learned court below.
Just. Page number where he is stated, page number.
Later on, it is not a fact, it is not a fact. Thereafter, later on, I come to know, page 14.
Hmm.
Later on, I come to know from my daughter-in-law, Josnara Begum, that her father, Hassan Ali, lodged FIR about the occurrence.
Hmm.
Neither this Hassan Ali was made a witness, nor he was examined, nor the statement was, if it was indeed a statement, then it ought to have been the statement of this Hassan Ali would have been very relevant to this case. The other thing, Lordship, that the IO PW 13. What I want to impress upon your Lordship is that right from the commission, right from the
Page number.
page 36, the entire story of the prosecution
Yes.
is doubtful from the very beginning itself.
Hmm.
Later on, the witnesses, even the investigating officer conducting the investigation from the very beginning till the last, he was also skeptical as to who were the accused who had taken part in the commission of the offense. What he says is very relevant. I made a note, page 36, I made a note in the case diary regarding the occurrence of the case, which is as follows.
Page.
Page 36.
Yes, I made
Yes,
an investigation.
I made a note. During investigation, I visited the place of occurrence, recorded the statement of witnesses, caused medical examination of the injured, and sent the dead body for post-mortem examination, and also arrested the accused person. During investigation, I come to know that on 14/9/2007 at night, theft was committed in the house of Sri Punaram Kurmi, and on 15/9/2007 in the morning, finding some of the stolen articles near the house of Abdul Ali, the villagers brought Abdul Ali, his wife Jaleka Khatun, and his son Tajabur Ali for interrogation. And thereafter, the villagers confined them and caused assault on them. And as a result, on 16/9/2007, in the morning, Abdul Ali expired and Jalika Khatun and Tajabur Ali sustained grievous injuries on their person.
Yes.
Now, the specific version of the IO is that the villagers confined them and caused assault. There is no mention of any accused persons. The investigating officer himself is skeptical about the role played by any of the accused, Lordship. He simply, the investigating officer who has conducted the investigation, he has to be very specific as to the role played by the accused persons. If he is skeptical, then the entire prosecution case itself is doubtful. He is skeptical.
Yes.
That is why he mentions the name of the villagers, but he falls short of naming any individual in this case. But on the other thing, then there are no eyewitnesses in this case. There was no intention by the accused person to commit any kind of homicide. And the accused persons are in custody for last 8 years. They have suffered immensely, Lordship. And my respectful submission is that they are liable to be acquitted.
Nico. Mr. A. Ganguly, learned counsel appearing for the appellant Punaram Kurmi in Real Appeal number 7 of 2007 has trodden the path traversed by earlier counsel. However, he has added a few submissions to bolster the defense and to bolster the appellant's case. It has been submitted that PW2 and 3 are interested witnesses, and as such, not much reliance can be placed on their evidence.
Other witnesses have not implicated the accused persons in any manner.
Full stop. Apart from these two witnesses, PW2 and PW3, other witnesses have not implicated the appellant in any manner. Hence, the evidence of PW2 and PW3 have to be seen, has to be, evidence has to be strictly construed, being interested witness. Even further submitted that neither the evidence, neither the statement recorded of any of the witnesses during the investigation of 161 or 164 CRPC or the statement made by the witnesses disclosed any specific role played by the present appellant. On the contrary, there is evidence to the fact that the violence was perpetrated by a mob. And under such circumstances, it can be said that the motive can be said to be established against the appellant for committing the offense, and for conviction under section 302 IPC. Mr. Ganguly also had drawn attention to evidence of PW2, who during her cross-examination stated that later on he came to know that her daughter-in-law, who is the wife of her son Ajijul, later on she came to know from her daughter-in-law Joshnara Begum that her father Hassan Ali had lodged an affair about the occurrence. But there is no mention or there is no reference to that affair in other evidence except for this evidence of PW2. If the said statement of PW2 is to be taken as correct, it would indicate that there were two affairs. First, one filed by the by Hassan Ali, aforesaid Hassan Ali, and another filed by her son, namely
Ajul
Ali. Therefore, a question will arise: which of the two affairs were first lodged? For only the affair lodged first will have its significance as an affair, and subsequent affair cannot be said to be affair on the same incident, and it has to be taken as a statement of a witness. Unfortunately, there is nothing on record about the aforesaid second affair lodged, thus creating a doubt on the actual reporting of the case, initial reporting of the case, as to whether the affair which has been formally exhibited is the first affair which portrays the picture, but the said cannot be ascertained for the reason that the second affair which is mentioned by PW2 has not been at all exhibited. It has been further submitted by Mr. Ganguly that the prosecution itself in a very shaky, it started with a shaky ground and ended with a shaky stand. When the investigation was launched by the IO, he himself mentioned during the cross-examination that he had made an entry in the case diary that during the investigation he came to know that on 14/9/2007 night theft was committed in the house of Punaram Kurmi, and on 15/9/2007 in the morning, finding some of the stolen articles near the house of the deceased, the villagers had brought the deceased, his wife and his son for interrogation, and thereafter the villagers confined them and caused assault on them. As a result, the deceased died. However, no particulars of the villages are mentioned, which would indicate that the IO himself did not know the identity of the villagers who had apparently confined and assaulted the deceased and his wife and son.
This is all the more relevant, Lordship, because this note of the IO was exhibited as Exhibit 13.
And it has been submitted that this particular note was also exhibited Exhibit 13. Thus, the very beginning of the prosecution story starts with ambiguity, not with clarity, as regards the identity of the assailants. Further, as submitted by other counsel, Mr. Ganguly submits that as have been also submitted by the other counsel for the other appellants. These are very general and vague allegation against a mob without specifying the role played by each of the accused appellants, so as to fasten the guilt on them for committing offense under section 302 of IPC, for which the ingredients of intention is required to be proved, which cannot be said to have been proved at all, as it was a mob violence and not individual acts of the appellants. Accordingly, it has been submitted that an overall consideration of the evidence record, it can be said that the prosecution has been able to prove the charge against the appellant beyond reasonable doubt for conviction under section 302 IPC. Next counsel, yes, Mr. You want to say on the medical evidence?
Both,
Huh?
both.
Okay, very well. Please. You are in item number
11, Lordship.
11. Okay, yes. Jogadish, yes.
Jagadesh Devdi. Lordship, I want to point out some discrepancy in the prosecution witness, perhaps that those discrepancy or material discrepancy. First of all, Lordship, the evidence of Tajabur.
Evidence of
Tajabur.
Tajabur.
Page 15, Lordship. Before that, Lordship, may have clear one thing.
Yes.
Lordship, so far as 161 and 164 statement is there. Lordship, they have uttered three names. Punaram, Bogai, and Boksan.
Punaram,
Bogai, and Boksan.
Boksa.
Boksan.
Boksan.
Three persons.
Yes.
Yes. And so far as the other accused are that they are in 164 statement by the PW2, Lordship. Others, some title or full name is not there. Some title, suppose Jagadish Devdi. Jagadish Devdi is not there, Devdi only. In 164 statement.
Yes.
I am for the first time after 5 years, the other's name came in their deposition. Neither 161, 164 for the first time, the name of other accused persons, they have deposed in 160 in the court.
In the 161, let us see that the 164, which have been executed by the magistrate.
Yes, Lordship.
Whose names are mentioned.
This is Tajabur.
Huh?
Tajabur.
Page.
Page 86. Lordship.
Page 86.
Very deep.
Yes.
On around 1 p.m. on 15/9/2007, while my father Abdul Ali, mother and I were in our house, our 8 neighbors. I do not know their names since I stay most of the time in town, but I will be able to recognize if I see them. Armed with lathi, come to our house, drag us to their house, and assault us till 4 p.m. Accused Boxon, one name is there. Injured my both legs by inflicting cuts with dowel. I saw Boxon dealing kicks on the chest of my father. Thereafter, I fell unconscious. I regained my senses about 6 p.m.
And this Boxon is not charged or what, appellant?
Yes, we.
Which one item number?
Babul Bora alias Boxon.
Okay, Baro. Mr. Hozarikas, okay, Boxon.
Yes, sir.
Oh, that's why he said, well, 161 was not exhibited. So I cannot use it. Huh?
It's exhibited.
Exhibited by the witness,
It is
by the,
exhibited.
not by the maker of the
Yes,
statement,
sir.
but
One-
by the cassette player,
Yes,
recorder.
Yes, that's it.
Because the magistrate doesn't know, he's just recording. It could have been recorded by a computer also, no?
Since he recorded, he.
So
exhibited
obviously, it cannot be contradicted through the mouth of the magistrate.
When of the magistrate was not put to question whether.
No, how does it, there is no point asking because the magistrate won't know what is
Yes.
right or wrong. Magistrate simply cock,
Record
keyhole,
the statement.
keyhole, cock. So he is okay.
Yes.
He just said chronicler. He is not a participant in the event. He is a chronicler, recorder.
Yes, sir.
He just records.
It was some-
Okay, okay. Yes. So apart from accused Boxon,
Yes.
he has not mentioned anybody else.
Anyway,
According to else, including you.
my-
You are
These are- okay,
Jagadish Deori.
Jagadish Deori,
So Jagadish Deori not mentioned.
not mentioned.
Not mentioned. Yes, next. Sure.
Next is Lordship. Some of the material witness, Lordship, whose names in the entire proceeding comes again and again, but
Yes.
police has not examined them.
Yes.
That is first one is Lordship, Ramesh Kurmi, Paharia,
Hmm.
where the
Hmm.
victim along with the 2 injured witnesses brought by the
But he is not in the final stage of the incident. He is just passing through. He is just a railway station, not the final destination.
entire
Final destination is Guwahati, sorry, this that school.
Yes,
Other-
Lordship, that is why discrepancy is there, contradiction is there, because they say these 8 accused persons brought background from their house. That means from their statement, if we go by their statement, we can see that from the very beginning to the end, even after that, the 3 accused persons guarded them.
Yes. So what do you want to, 164, anything else you want to say? What do you
164
mention?
nothing.
Okay, that's all, only that Boxon.
Boxon.
Then next,
Another part is Lordship,
you mentioned that Ramesh
Ramesh
Kurmi,
Kurmi.
then who else?
Josnara Khatun.
Josnara Khatun.
Uh,
Khatun, because she's the one who informed PW
Yes, Lordship.
two. Then apart from that,
Even from the witnesses of PW 1 and 2, we
Okay.
found that she go to the place of occurrence,
okay, Josnara.
Josnara.
Then who else?
And another.
You don't
is-
have to examine every witness.
No, Lordship.
Only they are not very important. They are the critical witness. They are not a critical. They are just 100 witnesses. If you witness examine 10, they are good enough. You can
No,
convince.
Lordship, can imagine a person is 2-3 person has brought someone to a specified house, Lordship. Nobody of that house, if does not examine by the prosecution, it is
So then, so we
It-
presume that he was taken straight to the school, not to
no, Lordship.
Ramesh Kurmi. Anyway, then
And
Josna Khatun and who else has been examined according to
Abdul
you?
Matlib.
Abdul Matlu. Who is this?
This is the person who informed Because
Okay, who informed the IO?
IO.
Okay,
GD entry was made on the basis of his telephonic
okay,
information.
okay.
And another doubtful prosecution, there it creates a doubt regarding the name of Bijoy Pagak, let's say.
Bijoy.
Yes.
But he runs away, what to do? He is absconding, what can the police do also? He's the one who has run, no? Absconded, no?
No,
Bijoy.
he was lordship acquitted by the.
Acquitted, but then, he was not physically present in the trial because he absconded. Bijoy
Pagak.
Pagak. So how can you examine him? He's not available. The police is not able to catch him.
No, my argument, lordship.
He has been
if-
acquitted
No,
what do you call it?
lordship, what my submission is that even police did not try to press out the rule of Bijoy Pagak event.
Because they couldn't, because he was not available for interrogation. If he had been interrogated, he would have disclosed to the police.
No, lordship, what in the cross-examination of the IO, what the IO stated, lordship, kindly have a look at.
Yes.
Page
Bijoy Pagak,
37.
page 37.
Yes, lordship. Witness so and so stated her statement that's about the name of Bijoy only. I have not ascertained whether Bijoy whether that Bijoy is accused, Sri Bijoy Pagak, or anybody else. Witness injured Tajabur Ali also stated in his statement about the name of one Bijoy only, but I have not ascertained. Yes, Lord. But I have not ascertained whether that Bijoy is the accused, Sri Bijoy Pagak, or anybody else.
If you look at the statement, I
He
have not
even does not bother to ascertain who are the persons. Next, it is not a fact that
Yes, yes.
so and so that the house of Bijoy Pagak is situated near the place of occurrence, and he had a fair price shop at a distance of 100 meters away from the place of occurrence. At that time, incident took place. Next line. It is not a fact that the accused Bijoy Pagak was in his fair price shop at that time. I did not record.
But who is this person? IO, okay.
Did not
Okay,
record
okay.
the statement. Last sentence, it is not a fact that accused Bijoy Pagak was not involved in the occurrence of the case.
Then yes. Next point.
And next is, lordship, the inquest report, lordship,
Inquest
and
report.
the statement of the witnesses. Inquest report itself
Please,
is, lordship.
what do you want to say? Inquest report,
Yes.
what with that? Inquest report,
No, sketch map, sorry,
sorry.
page
sketch map.
99.
Page
Page
99, not inquest report,
Not
huh?
inquest report,
Sketch map.
sketch map.
What do you want to say?
Regarding the place of occurrence.
Yes.
Place of-
Uh,
This sketch map,
yes.
injured dead body, C, D, E. These are the positions. C is the dead body, D injured, wife of the deceased, and E is the son of deceased. All
D
are,
and E.
and yes, and
They are nearby, yes.
A is number one. This should be personal road.
Person,
Personal road. The dead body and the injured person were found by the police on the road, lordship.
road, yes.
Road. But if lordship will go through the statement of PW 1, no, 2 and 3, lordship. They said that police recovered as somebody has brought the dead body from the jungle. Regarding discovery of the dead body, discrepancy are there in between the sketch map, statement of PW 2, 3, as well as Dilip Dutta, that is 1, PW.
Dilip Dutta is the inquiry authority.
No. Dilip Dutta, perhaps it is PW 5, 6, 5.
Dilip Dutta, huh?
Yes.
What does Dilip Dutta say?
Dilip Dutta says that
Who is he? Dilip Dutta?
Dilip Dutta is a person whose house is situated nearby.
Hmm.
The place of occurrence.
What does he say, Dilip Dutta?
He says that no, Jalaka not forcibly gone.
Page, Dilip Dutta.
Page 20.
What does he say?
He said on the next
I
day.
arrived home, came to know from wife.
Lordship,
Oh,
first
he
party-
doesn't know.
No, first part is not required. Regarding dead body, Lordship.
Okay. On the
Incident
next day.
at about
I went to see, yeah, by the time he come, he must, dead body may have been shifted here and there.
accordingly, I
Every
went
time
to
I
see
found
the dead
Jalika
body.
Khatun dead body,
No,
here
sir,
dead body.
21 page, Lordship. Accordingly, I went to see the dead body at
And number
number 1
Punch
Pasnoi.
Nui.
At that time, I found Jalaka Khatun Tajapur near the dead body of the deceased around so and so. Same day, police arrived at the place of occurrence. Learned executive magistrate, not what is the exhibit 1, he has proved. I visited the place of occurrence to see the dead body of Abdul Ali. At that time, I found 2 sons of the deceased person with their mother. When I asked Zalekha Khatun about the occurrence, she told me that so and so person. On the other hand, Tajabur Islam and Azizul were there before arrival of the police. This particular statement contradicts the statement of the PW 2, 3.
In what way?
And 4. Because the PW 5 series there, the 2 sons were present there before arrival of police. I found 2 sons of the deceased with their mother.
Yes.
Last this line.
Yes.
On the other hand, Tadabul and Azizul were
There before the arrival of the police.
arrival of the police. At the time, asked 2 sons. Lordship will find the evidence of PW 2. Daughter-in-law, page 13, Lordship.
Yes.
At about 10 a.m., my
Yes.
daughter-in-law, wife of my son Azizul, arrived there. On being aware of the occurrence, she reported the same to her father, who informed the police about the occurrence. Accordingly, the police arrived at the place of occurrence and took us, therefrom, to the court and thereafter to the hospital.
What discrepancy? What is the discrepancy you want to show?
Let's see, it is there. Procedural, come to page 19.
Yes. Is the evidence of PW 4.
4.
Yes, what do you want to say?
What he says, Josnara, his wife informed him over telephone. He came immediately to his house. Thereafter, on the next day, I came to my house. I went to the house of my father-in-law, Hassan Ali. Thereafter, came to North Lakhimpur police station. Along with my father-in-law, I lost the affair. Thereafter, police took us along with them and proceed to village Pasnoi.
Yes.
Then police party started searching abducted persons with the help of Hassan Ali and myself. Remain in the police vehicle. After some time, Hassan Ali and one Datta, that is Dilip Datta, PW 4, 5, brought the dead body of my father near police vehicle. So, Lordship, if the sketch map is correct, it is on the road, Lordship, it is public road. But on the other hand, they said that they have charged the dead body PW1 says that the police went there, asked her to for a lamp.
Hmm.
Her husband accompanied with the lamp and find out the dead body.
Hmm.
PW4 says that
Hmm.
he and his father-in-law accompanied the police,
Hmm.
and after searching by his father and one datta, the dead body was found. They brought it near the police vehicle.
Okay, then any other contradiction? Any other contradiction you want to highlight?
Yes. Yes, Lordship. Another, the injury, Lordship.
Yes.
Their statement is Dao, Kukri, and Lathi.
Yes.
Dao and Kukri eliminated so far as if go through the evidence of medical evidence.
Hmm.
What is there? Blunt weapon is there.
Hmm.
Now, the nature of injury, Raster, PW 2 and 3, they have received PW.
Page number. PW page number 15.
No, Lordship.
Which one you are reading? Report. Postmortem.
Yes, before postmortem, but the two reports, that is 70.
Page number.
75 in this.
Page 92.
Yes, Lordship. 81.
Postmortem report.
No, Lordship, it is injury report.
Injury report page.
Chaleka Khatun, page 81.
Page 81.
And
Okay,
hers-
injury report. Yes, what do you want?
80 is.
Yes, what do you want to say?
These are,
Blunt.
yes. Simple. And blunt weapon.
Hmm. Yes.
Now, Lordship will go to the inquest report.
Page 82 also.
Yes.
Yes. Inquest
Inquest
report.
Page 57.
Page 57.
75.
Your agent? Huh? Single bench. How long will it take?
15 minutes.
15 minutes. One more counsel also. You are for whom? Huh? Anubora. Then the court says 3 PM. I don't know what to do. Single bench matter also there. How long the single bench matter? Some argument. No? Single bench also. But you are not available tomorrow. You are going today. Tomorrow. What time? Flight.
Tomorrow perhaps not possible.
Afternoon.
Huh?
Afternoon flight.
Afternoon flight.
Then next, when you will.
Lordship, their first contention was that they have completed their part, my lord.
Ah.
Now they are arguing your lordship.
No, but we have already argued, no?
Lordship, I have argued, but
Then-
All
no,
the cases are already argued, my lord.
Ah.
so far as this,
Submitted your
what-
lordship,
what-
some parts are to, they have to make
extra,
submission.
what
They
I
say that no.
want to show to your Lordship is that the injury and
Then we have seen that, yes, then apart from that, anything else you want to argue?
yes,
That-
Lordship.
Apart from that, we have noted. The injury, the simple injury, all blunt and
No,
simple.
no, some other Lordship decisions because what is subdural hematoma is there.
Yes.
No other injury, only subdural hematoma.
So shows that subdural. But what about you? We have heard you last time. We have heard you, then why should we hear you again and again?
On last occasion, after hearing the matter, your lordship was asked me whether the case will fall under section 302 or 304B.
Judgment,
Only that aspect I.
that judgment you give that. Yes, you tell us subdural hematoma. Tell us, because we want to finish it today. We'll rise after some time for the single bench. Huh? After some time, we'll complete this DV. Yes. Tell us. Judgment, give. Question of law, no problem, give. Just tell us what is the low point in that decision, that's all.
So in running page, I have marked for.
Yes.
It's page 41.
Page 14,
There is a
yes.
Judgment by the Orissa High Court, Benugopal Panda,
Yes. You
page
tell us what is, yes,
46.
shows the relevant portions only.
Yes, sir.
Yes,
Page 46 at serial number 7,
yes.
subdural hematoma left side.
Ah,
Apart from there are various injuries. This is
So what do you want to say? Tell us. You tell us.
let's say these what in this is a peculiar case where no weapon, where nothing has been seen,
Okay, very well.
and the nature of injury which the disease has suffered and which caused that, that is the head injury, without there being there is a subdural hematoma without corresponding external injury.
Okay.
Nothing is there in chai zone, lacerated zone, nothing is there in skull, outer side of the.
Yes. So neither inside nor lacerated wound.
Nothing
Nothing there. That's
is
all.
clear
Okay.
because inquest report as well as medical.
Okay. Anything else?
Rupture of liver is there. Liver is ruptured. Apart
Oh.
No, liver is not a cause of death. Cause of death is the head injury, Dr. Wine.
Okay, then yes.
Yes, Lordship. Here, Lordship,
Then?
some medical Lordship jurisprudence decision was taken up.
So yes, come to the relevant para only.
Yes, Lordship.
Para number?
Para number, Lordship, it is page 47. Headline is that blunt head injuries to head. These are the most common. That is the sentence. Lordship. Skull, next headline, Moody's Medical Jurisprudence and Taxology, 20 edition. Skull, fracture of skull or sometimes caused without so and so. Fracture death may result from violence depends on the weight and velocity of the weapon. The most amount of force, the type applied use, that is a blunt or cutting weapon or a pointed or edged object.
Okay. Okay, we have understood.
Yes, Lordship. In absence of seizure of the witnesses, the
No seizure of weapon And also there is no injury. Nature of injury, no, neither incise wound nor lacerated.
Yes, and that has not been explained by the prosecution.
Okay.
Therefore, let's say, normal principle is prosecution has to prove his case beyond reasonable doubt.
Yes.
Yes, there are some doubts regarding the use of weapon, involvement of the persons, because if 161, 164,
Yes.
they do not utter the name of any of the, although they are post-ledgers,
Okay.
they even in the FIR, nobody's name is there.
Okay.
Lordship, and if in case of then the version of the PW 1 and 2, 2 and 3, Lordship, lex credence, Lordship, because after 5 years, all of a sudden before the court, they started to tell the names minus the 3, because in 161 for statement they have mentioned 3 names.
Yes. Next.
One, Lordship, 34 regarding common intention.
Common injury. Yes. Yes.
Lordship. Lordship, from the evidence, it appears that first part, bringing the persons to a particular house of yes, Ramesh Kurmi Paharia. Thereafter, if Lordship will go through, although it is not in evidence, but in 164 statements, somebody after taking them to the house of Paharia, people asked, question them, thereafter handed over to the VDP's, Lordship. That was PW, who is PW 8, Lordship. In her 161 statement, it is there that these particular accused victim and deceased were handed over to the VDPs.
So why you are bringing 161? Has it been brought on record, that portion, by way of contradiction? No.
Lordship, regarding that,
PW 8, you say, no, 161 statement, they made it.
there is not question.
Then let us not argue on that. Let us not, don't bring answer.
Lordship.
These are prohibited articles. 161 is prohibited, totally prohibited.
Now prohibited, if not brought in.
If not brought on record.
Yes, sir.
Yes.
I am, Lordship, in that is one judgment, that is in the compilation, Lordship.
Yes, yes.
Jasdeep Singh, Lordship.
Page number?
Running page is not there, Lordship. I marked it.
Jasdeep Singh.
Yes.
Two
22, 1 SCC, 96. Let's see, perhaps it is Jagdeep Singh.
Where? Jagdeep Singh, huh? What do you want? What do you want to say?
Regarding common intention. Para 36 to Lordship.
Jasdeep Singh.
Yes, yes.
Para?
It starts from para 36 to 42, Lordship. 42 is not reversed, 41, Lordship.
What does he say? Go low relating to
Meeting of minds.
Okay.
Lordship, the ingredients as well as
okay.
even in some cases, Lordship, there are common intentions. Suppose 2-3 persons came for beating a person. Their common intention to beat, not to kill. Subsequently, one has exceeded the common intention. Other two may not be held responsible for that.
This is what this law says. Yeah, in this case.
There is a line.
Huh?
Yeah.
Para number?
Para
or page number, internal page number of this judgment you have?
Evidence.
There are 18 pages. Which page? There are 18 pages. Which is the page we are referring to?
15 to 18, I think.
15? 15 by 18?
15 by 15 by 18.
15 by 18.
For bringing 34.
Okay, we have understood. Initially, just to teach him a lesson. Chalo.
Yes.
We'll teach him a lesson. Slap, but thappar maro. Huh? Then one fellow exceeds that force.
Exceeded it.
Then only he can be maximum. No,
Because
it cannot be extended.
pre-meeting of mind to kill him
what?
is not there.
Yes. Okay, then. Huh?
And next is Lordship, what I want to submit before your Lordship, although there are eyewitnesses, 4 eyewitnesses.
Yes.
4 eyewitnesses, 2 were injured eyewitness
Hmm.
and 7 and 8.
Yes. 2
7
other
and 8.
here.
They are independent witnesses. They while convicting these persons, accused persons, they learned trial court even not referred to the statement what has been made by the 7 and 8.
Because they were bought over. But there is no evidence. Huh?
Yes.
Okay.
What they have said, these interviews.
Okay. Yes.
2 and 3 can be accepted. Lordship.
Okay.
But the material contradictions, Lordship,
Yes.
it is not safe to convict the accused persons
Yes.
because prosecution has failed to establish the case beyond reasonable doubt.
Okay.
And
Well.
it is not safe.
Then next.
Lordship, dismiss.
That's all.
Lordship.
Okay, Likho. Mr. Dotto Lane counsel for the appellant Sri Jagdish Deori in field appeal number 17773. Who submits that? Who submits that? Though the names of 3 accused, namely Punaram, then Bogai, and the Boxon were mentioned by the witnesses in the statement record 161, 164. But other accused were not mentioned name in full. But somehow, in course of trial, the name of these 6 accused were mentioned, which creates a doubt on the veracity of these witnesses. Coming to the evidence of, referring to the evidence of Tadabor, made under section 164, which was recorded soon after the incident. He states that he only he said that though he knew the accused, he cannot name them by name.
Right.
However, he mentioned the name of Boxon. So what do you want to say by this?
No, by this, Lordship, in the FIR, their name is not
Okay,
there.
very well. Huh? Okay.
In the 161 and in
Okay.
164
Okay.
name is not there.
Okay.
But in cross-examination, he stated that these are co-villagers. I know them before the incident occurred.
Okay. Okay, very well. However, it is to be noted that the name of the accused, none of the accused names were mentioned in FIR. Further, in the cross-examination of PW
3, Lordship.
3,
Yes.
page number
It's number PW.
PW3 page number, that cross-examination
Three, 16 page number.
16.
Yes, sir, Chief.
PW3 task board states that he knew the accused persons,
The accused persons are my co-villagers.
that the accused are co-villagers, and they were known to him prior to the occurrence by name.
By name.
Therefore, it is very clear that while in the statements made soon after the incident, he could not name them. Later on in the trial, he testified that he knew them prior to the incident by name, which creates a doubt on the veracity, credibility of his evidence. Learned counsel for the next para submits that there are some important personal actors involved in this incident, namely Ramesh Kurmi, whose house the deceased and the injured persons were initially brought by the villagers. Though has been named by several witnesses, was not at all examined. And his evidence could have shown more light on the actual incident. But nevertheless, he was not examined. The witness Josna Khatun, no? Josnara. Mentioned by whom? PW? Josna was mentioned by PW?
2, 3.
PW 3, 2 and 3 also mentions one Josnara Khatun. He's a daughter-in-law or what? Josna
Yes,
Khatun.
daughter-in-law of the deceased.
Daughter deceased.
Yes, yes.
From whom?
2, 3, 4, and
2, 3, 4 and the
5.
5.
5. No,
Mentioned
5
name
is not there. 2, 3, and
Josna Khatun, who also knew about the incident, but she also has not been examined. Thirdly, the IO had mentioned in his testimony that he got the information telephonically from one Abdul Matlib, on the basis of which he made the GD, General Diary entry, and started the investigation. However, he was not examined. According to Mr. Dotto, examination of the said Abdul Matlib would have been critical, as he was the first to inform the police about the incident. However, according to Mr. Dotto, the non-examination of these witnesses were very much in the knowledge of the incident would cast a doubt on the veracity of the prosecution witnesses. Further, it has been submitted that though some of the witnesses specifically mentioned the name of Bijoy Pogag, what role he had played has not been stated by the prosecution. Though he may have absconded, yet his role could have been ascertained from other witnesses. But the police did not do the said exercise. Next paragraph. Further, it has been submitted that there is some doubt about the place of recovery of the dead body. Though the sketch match indicates that the dead body was found on the road, it has been mentioned by other witnesses that the dead body was found near the Basnoi school. There are also evidence that his dead body was recovered from jungle. Therefore, there is inconsistency as to the place as regards the place from where the dead body was recovered. According to it has been submitted that the prosecution case is not consistent in that regard also. That the dead body was recovered from the next. Learned counsel for the appellant also has submitted that though there is a reference to use of dao, kukri, which are sharp weapons, allegedly by the mob, from the record, it's clear that these were never used. In as much as the injury reports does not indicate the use of any such sharp weapon. On the other hand, at best, such an injury could have been caused by a blunt injury, a blunt weapon. In fact, in this regard, Lana Counsel for the appellant has drawn this court to the injury reports of the two victims, witnesses PW2 and PW3, where it has been clearly mentioned that the injury received them were simple in nature and also caused by blunt weapon. Lana Counsel for the appellant also submits that injury received by the deceased also does not indicate that any such sharp weapon was used. What is mentioned is the damage, the injury in the subdural, page 41.
Yeah,
Page 41. Page 41. What is that? What is that? Page?
Page 94.
94.
Yes, second 3.
Ah.
1, 2.
What the injury which has been indicated in the on the body of the deceased was hematoma over left temporal region,
Within brackets.
which does not at all within bracket subdural, which only reflects that it could have been caused by a blunt object only, not by any of the sharp weapons mentioned. Otherwise, even use of blunt weapon also doubtful, in as much as use of a heavy blunt would have left some kind of injury, either incised or lacerated. But no such injury has been found. The prosecution also has not explained the nature of injury received by the deceased. Thus, it cannot be said that the prosecution has been able to prove the case beyond reasonable doubt. Stop. Next paragraph. It has been further submitted that the identity of the accused also not very clearly spelled out, in as much as the FIR does not mention the name of any of the accused, though the names are found, some of the names are found in 161 or 164 statement of the witnesses. Only when the trial was conducted after about 5 years of the incident, the witnesses clearly mentioned the name of these 6 accused. Therefore, it is very doubtful as to the genuineness, credibility of these witnesses. It has been also submitted that while 4 witnesses where there were 4 eyewitnesses, while the prosecution examined 4 eyewitnesses, out of which 2 were the injured related to the deceased, 2 others were independent, that is PW 7 and 8. However, the trial court did not consider properly the evidence of PW 7 and 8, who stated that they did not see the accused at the place of occurrence, but relied primarily on PW 2 and 3, who are the injured eyewitnesses who are also interested. It has been further submitted that the prosecution also has not been able to establish the meeting of mind of the accused for committing the aforesaid alleged offense. It has been submitted that to convict and accuse a number of persons under section 302 for murder under section 302 IPC, it is necessary to prove that they had a common intention to cause the death and murder prior to the incident. But in the present case, no such evidence is forthcoming. On the other hand, what could be gathered from the evidence is that because of the activities of the deceased, who was alleged to be involved in theft of cattle, the mob perhaps wanted to teach him a lesson. However, the action of someone in the mob had exceeded, resulting in the fatal injury, causing fatal injury on his head. Therefore, it cannot be stated that there was any common intention or meeting of minds of the persons involved to cause the death of the deceased. It has been also mentioned, example submitted that no weapon of the, ये पहले ना cause ना that injury ना उसमें लिखना that the weapon of crime was not seized, and as such it cannot be established how the injury was caused by the it cannot be established by the prosecution how the injury was caused. Thus, the prosecution case lacks clarity as regards the persons who are involved in the alleged commission of offence under section 302 or about the nature of injuries caused, which nature of weapon used for causing the death, apart from other discrepancies which have been pointed out by learned counsel for the appellant. Learned counsel for the appellant also has relied on the decision of the Honorable Supreme Court in that first judgment you wanted that Jagdish, no? The first case?
Lordship, first is first one, Sunil Kumar.
Okay, page 41, huh?
No, Lordship, this is bottom, okay, at the top.
Which one? Which one you wanted? You mentioned two judgments, no?
No, Lordship, at that time, no, this Sunil Kumar.
What is this? This is for what?
Paragraph 17.
Learned counsel for the appellant has relied on decision of the Honorable Supreme Court in Swenso, Sunil Kumar, Dr. Sunil Sumba Swenso versus State of Maharashtra.
Yes,
in which it has been held. What? Page?
Page running page by hand, Lordship, 12. Para 17.
Para 17.
15 to 17, Lordship. 14 to 17 regarding non-mentioning in the name of the FIR.
To submit that non-mentioning of name in the FIR would be fatal. Then?
No, not only that, Lordship, non-mentioning of FIR 161 statement, not disclose certain facts. Paragraph 17, Lordship.
Okay, non-mentioning the names of the persons accused in the FIR or in the statement recorded by of the witnesses under say 161 would be fatal to the prosecution case. Then next
is Lordship. 2002 page 19, Lordship.
What this is for what?
6, 7, and 11. No, Lordship, this is not.
Then yes.
Balagopal.
What do you wanted?
1990 criminal law.
Balagopal Panda versus state of the state.
This paragraph 14, Lordship.
1990 Criminal Law Journal 1848, in which the nature of injuries.
Yes, Lordship.
In which the nature of injuries which would indicate the in which the nature of injuries has been explained, considered. Which would indicate the kind of weapon used.
This judgment say if someone suppose 6 inch very heavy seat, Lordship.
Which would indicate the nature of
Postponing-
weapon which are used in the crime. Yes. Next is
Lordship.
existing justice.
2022 1 SCC 96.
I also relied on decisions where relating to common intention.
Yes, Lordship.
by holding that if there was no prior meeting of mind,
36.
comma,
para 36.
meeting of mind, a combined intention cannot be inferred from the subsequent acts.
Let's next is
Yes. Yes, next is,
so this is a Supreme Court Sosipal.
you also this on Sashipal Shishu versus state
Yes.
of
Yes.
the state NCT Delhi.
Para 20 to 27
Para 20,
to 27.
what is about
This is also in regard to common.
regarding common test. That's all?
That's
And-
not-
Okay. Yes, you wanted to cite some judgment, you cite the judgment.
Already I have earlier given one compilation of judgments. and,
Okay.
I have already submitted paid for acquittal of the appellant on certain grounds. I have brought some contradiction before your lordship. And whether it is on record or not, I do not know, lordship. Already those points I have already placed before your lordship. That PW 2 and 3 are not reliable witness by bringing those contradictions, lordship.
Okay, yes. Yes. 10 pages. There, noted. We'll try to retrieve our information from this.
Sure.
Recollect, remember the memory, reconstruct.
Sure.
Reconstruct our memory from these pages.
Only with that, lordship, just one thing your lordship will kindly add, lordship, in my submission, lordship. In the FIR, just reading one line. The informant stated that I have the honor to state that around 1:30 PM on 15/9/2009, some persons of nearby village called away my mother Julia. So nearby village, it is said in the FIR. But PW 3 in the FIR in cross examination admitted that the accused persons are his co-villagers, not nearby villagers only. Their aspect, lordship. And just regarding that 302 or 304, lordship.
Yes, yes, yes.
Paragraph 7.1.3. Your lordship will find
This
page
one,
10.
Stalin, Stalin.
Yes,
Okay.
page 10. Internet, the top portion, your lordship will find page 10.
Para
7.1.3,
page
10. Your lordship.
okay.
May I read?
Yes, okay, don't. That's all?
Lordship.
Yes. Huh?
Few minutes,
2 minutes,
few minutes.
few minutes.
Lordship, the case of the defense is that your lordship, there was no previous enmity. Lordship, there was no prior meeting of mind. Weapon was not seized, your lordship. Material witnesses were not examined, my lord. And entire prosecution case is doubtful. And your lordship, the medical evidence doesn't support a prosecution case.
Yes,
And apart from that, there's no seizure of weapon, your lordship.
yes.
So, lordship, in this case, only two witnesses which are reliable, according to me, your lordship, who are the PW 2 and 3, who are the injured eyewitnesses. And my contention is that, your lordship, when injured eyewitnesses are there, it makes the prosecution case more stronger, your lordship. Here, the injured eyewitnesses are PW 2 and 3, your lordship, were at the place of occurrence. And they also received injuries, my lord, which are supported by the medical evidence.
Yes,
And your lordship, regarding the enmity part, your lordship, because this the victim, lordship, according to the defense, there was an incident of theft. So lordship, their motive part was, their intention was to kill him, your lordship. And in lordship 34, there is no specific overt act is not required when there is mob attack, your lordship. And I have to rely on some judgments only on that point, your lordship, regarding my lord. Regarding the specific overt act, 2009, 17 SCC 221.
Hmm,
221.
SCC,
2009, 17 SCC 221.
yes,
Akhlaq versus State of UP.
Akhlaq,
Yes.
okay, then
Para 30,
30,
30, 32,
okay. Then
and 29.
there are 29 also,
Yes.
yes.
Lordship, and one more judgment on specific overtime
Hmm,
that is not required under section 34. 2010,
yeah,
10 SCC.
2010,
2010, 10 SCC
hmm,
259. Abdul Sayyad versus State of MP.
Abdul
Sayyad
Sayyad
versus
versus,
State of MP. Para 49,
yes,
50, 56, 52 to 55, and 57.
yes,
Lordship, and para 25 and 27 also.
yes.
Lordship, the non-examination of material witness, they say that one lady and one person, I have not, Jafula or something like that.
Non-examination of,
Material witnesses, it's not fatal to the prosecution case, my lord. 2013. 7 SCC 45. Harivardhan Babu Bhai Patel versus State of Gujarat.
sorry,
Harivardhan Babu Bhai Patel versus State of Gujarat.
yes.
Para 23 to 27.
Hmm,
Then your lordship, 2004, 13 SCC,
2004,
13 SCC regarding non-examination of material witness.
huh.
2004, 13 SCC 308.
What do you want to say?
Regarding non-examination of these two material witnesses, the lordship, first victim was taken, dragged to a residence of somebody, your lordship, and thereafter his dead
So
body
this
was
will not be fatal according to
not
you.
better.
Hmm,
Then lordship, one more aspect, the different witnesses react differently, my lord. Although they have not made the submission, I may make submission. In 164, they may say something. In 161, they may say something in the lordship. In the substantive evidence, they may say, there maybe little bit of variance, my lord. Lordship, that it's not fatal, my lord. 99, 9 SCC to 525.
Nineteen,
99, 9 SCC 525.
yes,
Para 11, 12, and 18.
yes.
Leelaram Dev versus Dulichand versus State of Haryana.
Hmm,
Then your lordship, when there are injured eyewitnesses, it makes the prosecution case more, it gives more credence to the prosecution case, my lord. In that regard, 2010 5 SCC 68.
2000,
5 SCC 68.
68.
Yes, para 27.
Next,
Shokat versus State of Uttarakhand.
next,
Next is my lord, medical evidence vis-a-vis the ocular evidence. When there are ocular evidence, their lordship injured eyewitness, then your lordship will give credence to them. 2004, 13 SCC 308. State of MP versus Harkola Elias Gobind Singh.
2000,
2004, 13 SCC 308. Para 8 and 9.
Kera?
8 and 9.
Yes.
And lordship, in case of section 34, prior meeting of mine is not required, your lordship. 2014, 5 SCC 369. para 10.
2000.
14, 5 SCC 369, para 10. Pasupati Shiva Ramakrishna Rao versus State of April. Defense tried to protect this witness, injured eyewitness or innocent witnesses. Lordship, regarding the interested witnesses, para 9 and 12 of 1999, 9 SCC 525.
1999.
9 SCC 525. Neelaram date through Dulichan versus State of Haryana and another. Para 9 and 12. And
Yes.
one moment.
Yes.
Non-seizure of the weapon. 2013, 12 SCC 746.
2013.
12 SCC 746. Para 33 and 34. It's not valid for the prosecution. Lordship, the prosecution could stand on its own legs, my lord. There are injured eyewitnesses, and your lordship, the learned trial court, lordship rightly held that this person is found to be guilty. And as such, your lordship may appeal the judgment. That is my response.
Yes, Director, did you? On the prayer, on joint prayer, let the matter be listed on bench.
Well, affidavit in reply was filed by the petitioner, that was not on record, maybe.
2810.
Affidavit in reply filed by the petitioner may be placed on record.
Of my.
Filed today, you filed
Today.
today, okay. Reply affidavit, huh?
The reply.
Filed by the petitioner may be filed today, may be placed on record.
Much.
Please, your lordship, with the consent of the other side, I beg to mention 13 and 14, my lord, of the supplication.
13 and 14. Yes, please, the other side.
Yes.
Okay. Okay. Consent?
Yeah.
Okay. Okay, on joint prayer, the matter be listed on.
But earlier interim order may be continued.
Early interim order,
Review petition, there is no interim order.
In the review, my lord, there is interim order.
early interim order, if any, shall continue.
Yes.
In the review, there is no interim order.
Earlier interim order, if any, shall continue. If any. Fine, no problem.
3110.
Wait, please, your lordship, with the consent of the other side, I beg to mention item number 2 to 6, your lordship. In this case, I am led by Mr. UK Nair. He has some personal difficulty today. So may I pray the matter may be taken up after the vacation, your lordship, immediately after the vacation.
No, item number 2, I am appearing, my lord. He says some problem.
Okay. On the prayer, Mr.
Arsina,
On behalf of.
on behalf of the IRP, your lordship.
Also, Mr. BK Das. Standing.
Respondents.
Item number 3.
This one, yes, item number.
3.
She is my friend.
Okay, accept, just, can you just give the name, huh? Okay, Mr. 3 में लिखना, Mr. BN Gogoi, Mr. BN Gogoi. Then item number 4 also? No.
No, I'm only.
These are all 3 to 5 you mentioned, 3 to 6. In item number 2, Mr. BK Das. Item number 3, Mr. Dr. BN Gogoi. Then item, what about item number 4? Anybody? Anybody making any prayer? Adjournment? No. You are making, no?
Yes, sir, I am making.
So who is the other side? G Sharma.
G Sharma is not there.
चलो ठीक है लिख दो मोरे लिख दो बस।
Yeah, more concept I have taken.
अब सबको लिख दो then here G Sharma also again
Yes, your lordship.
N6 okay
Deep level.
please.
Please, your lordship. My lord, with the consent of the other side, I would like to mention item number 7. My lord, my.
Item number
7. My
Yes.
lord, my senior is out of station.
On a prayer of Miss, what is your name? A
Baby,
Devi
Yes.
on behalf of Mr.
age pura hua hai.
or for the respondent side.
Yes, my lord.
Yes, the petitioner side, anybody for petitioner side, anybody for Lico for the respondent number 4, praise for listing the matter
Yes.
after vacation.
After vacation.
Praise the Lord. Yes.
Obliged to your lordship. Lordship, I beg to
31
mention item number 8, lordship.
Yes.
We had filed an additional affidavit on 23rd of September, lordship.
Uh-huh.
However, the additional affidavit has not been tagged with the record, lordship.
Hmm. Which was the other side? Anything you want to say? Come up after vacation? When? Huh? Tell.
They also received that copy.
Sorry, you have not received.
Today I have.
You have received a copy. It will come up when?
Lordship, any date may be fixed.
Okay, on the prayer of Ms.
M. Das.
M. Das. Matter will listed on so and so.
31
Affidavit, you have filed an affidavit?
Additional affidavit.
31 10.
Additional affidavit filed by the petition may be placed on record.
Obliged.
May I please, your lordship? So I beg to mention item number 1.
Yes,
Matter may be taken up after the vacation.
on the prayer of Mr.
A. Ahmed appearing on behalf of R. Hussain. Highly obliged.
Next.
Daily list, item number 9.
Yes, what is this item number 9?
Have to come for appointment to arbitrator, my lord.
And he has agreed or he is resisting?
Well, it was registered on the ground, my lord, that there is no arbitration clause.
Oh, no arbitration clause.
Yes, well, that is only to be seen by the on the court, my lord. Your losses may just, my lord, come to that point directly, my lord.
Yes, let us see on what basis you have sought for arbitration. What is the arbitration
Right.
clause to us?
My lord. That's it.
Yes, yes.
I have filed a,
Sorry,
I have filed a written argument.
you have filed a
Written argument.
written argument. That there is no arbitration. Your plea is that there is no arbitration clause.
There's no arbitration clause.
Okay, let him
What
find
is
out.
sought to be-
Let him find out the thing which is
Well,
not there.
My lord.
Uh,
Well, from page 43, your losses
Page
may just see.
43.
Page 43 onwards.
General conditions.
My lord, clause number 12, my lord, your lord.
Reinstatement of sum
Sure.
issued.
Immediately upon happening of any loss, damage as described in the policy, total sum instead upon description of the property which may have been lost or damaged shall be reduced by the amount of loss and damage and shall be reduced to ensure limit of the company liability in respect of any further loss or damage occurring during the current period of insurance unless company has consents and upon payment of
Okay,
additional premium.
then-
Now, my lord, your losses may come to next page. my lord.
Yes.
Complaint to police authority is mandatory for loss occurring during burglary and housebreaking or attempt thereafter, loss or damage caused by the third parties. The insured shall render full cooperation to authorities for in prosecuting and any employee act for dishonesty resulting in the claim so and so. Then my lord, clause 15 your losses may see. This is the absolute clause. All aspects as to arbitration agreement, appointment arbitrator, terms of reference, award, if any, etc., will be in accordance with the provisions of Arbitration and Conciliation Act 1996 with amendments. My lord, this is the arbitration clause, my lord. Now we have
This has
sought-
been so well drafted.
my lord, that
by-
that is their drafting, my lord. We have nothing to say. Now
Oh,
we claim for appointment of arbitrator. They have refused, my lord, page 147, my lord. Your lordship may see. How they have refused it.
yes,
Page 147, last page.
yes.
With reference to your notice dated 26/11/21 regarding reference of the disputed subject as stated above, we wish to inform you that for the following two reasons, among others, arbitration does not appear to be appropriate forum for resolution of the perceived dispute. Two grounds. Firstly, since the claim has been paid in full as per limit stipulated in the policy as per policy terms and conditions, it cannot be said that there is a dispute on quantum of compensation. That is another aspect. The enhancement that
you are seeking relates to interpretation of the policy condition in the path of, in the garb of difference in quantum of compensation. Secondly, it may please be noted that there is no arbitration clause in the compact insurance policy as usually found in other standard general insurance policies. It may not be, my lord. As usual may not be. It is a different. The settled position of law that when there is no arbitration agreement between the parties without a joint memo or a joint application of the parties cannot be referred to arbitration. In view of the above, we hope that you are pleased to appreciate our inability to agree with your request to refer a matter of dispute. No, this is the ground, what they are saying, my insurance company themselves drafted it, and they say no arbitration clause in the so and so, as is usually found in other insurance policies. Well, is it I am responsible for that? That is drafted by them, my lord. That is why, my lord, the judgments are there, my lord. I shall place. My lord,
Judgment.
I'm giving you. Okay, my lord. First, my lord, I am referring to 2009 to SCC page 55.
Stand for.
Your losses may come to paragraph 15, my lord, onwards.
Paragraph 15.
An arbitration clause is not required to be stated in any particular form if the intention of the party to refer the dispute to arbitration can be clearly ascertained from terms of the agreement. It is immaterial whether or not expression arbitration or arbitrators has been used in the agreement. My lord, here, my lord, the laws and other things are there, other previous clauses, and thereafter this clause is there. Now, 16. The court is required to decide whether existence of arbitration agreement, therefore, a dispute to arbitration can clearly be ascertained from in the facts and circumstances of the case. Thus, in turn, it may depend upon the intention of the party to be gathered from the correspondence claim the parties and surrounding circumstances. My lord. Now, para 18, my lord. That an arbitration agreement is not required to be in any particular form has been reiterated in more than one decision. What is required to gather the intention of parties whether they have agreed to resolution of the disputes to arbitration? What is required to be decided? The application of section 11 of the Act is whether there is any arbitration agreement is defined in the Act. It needs no reiteration that section 7 of the Act does not prescribe any particular form and immaterial whether they are not expressed arbitrary or arbitration. Now, one paragraph, I'm just. Paragraph 25 also, my lord. Your lordship, okay?
Yes.
The submission is unsustainable for more than one reason. No party can be allowed to take advantage of the inartistic drafting of arbitration clause in any agreement as long as it is clear interest of the party to go for arbitration in case of any future disputes and evident from the agreement and material on record, including surrounding circumstances. So it is inartistic drafting by them, my lord. It is not myself. The other rule is also there in this respect. I'm coming. Now, my lord, I'm just giving another latest decision, my lord. This is 22 for FCC 582, my lord. This is rule of contra propaganda. Paragraph 45, my lord. Paragraph 45 to 50. The contra profundum rule has been as an ancient genesis.
when words are to be construed resulting in two alternative interpretations, then interpretation which is against the person using or drafting the words or expression which has given rise to difficulty in construction applies. This rule is often invoked while interpreting standard from context. Such context heavily comprise of forms with printed terms which are invariably used for the same kind of contract. Also, such contracts are harshly worded against individuals and not read and understood most often, resulting in grave legal implications. When such standard form of contracts ordinarily contain exception clauses, they are invariably construed contra profundum rule against the person who has adopted the same. Some of the judgments which have considered contra profundum rule are referred to so and so. In General Insurance Company versus so and so, it was held that when there is ambiguity in the contract of insurance or doubt, it has to be construed contra profundum rule against the insurance company. In DDA versus so and so, in construing the document, one must have regard not to be presumed intention of parties, but to the meaning of the words they have used. If two interpretations of the documents are possible, one which should give effect and meaning to all its parts should be adopted, and for the purpose words creating uncertainty in the document can be ignored. Now, in Central Bank of India versus so and so, what is called contra profundum rule should be applied as the policy was in a standard form contract prepared by the insurer alone. It should be interpreted in a way that would be favorable to the assured. In so and so, it was observed that when an ambiguity is the duty of the court to look into the parts of the document to ascertain what was really intended by parties. Even there, here, the rule has to be borne in mind that the document being a grantor's document, it has to be interpreted strictly against him and in favor of the grantee. And always, my lord, it says, my lord, that the drafter it should be against the drafty, my lord. In United Insurance Company versus so and so, my lord, same thing. Contra profundum, where there is ambiguity in the policy, the court will apply contra profundum rule. Where policy is produced by the insurer, it is their business to see that precision and clarity are attained. And if they fail to do so, ambiguity will be resolved by adopting construction favorable to the insured. Similarly, a Jagar's language which emanates from the insured, such as the language used in the answer to the question in the proposal or in the slip, the construction favorable to the insurers will prevail if the insured has created an ambiguity. This rule has, however, only become operative where the words are truly ambiguous. It is the rule for resolving ambiguity and cannot be invoked with a view to creating a doubt. Therefore, where words are free from ambiguity in the sense fairly and reasonably construed, they admit only one meaning. Similarly, my lord, in other cases are also referred to here, my lord, up to 50, my lord. Yeah. Just let's see, your lordship may come to paragraph 48 also. The contra profundum rule of the construction arises only where there is a wording employed by those drafting the clause which leaves the court unable to decide by ordinary principles of interpretation which of the two meaning is the right one. One must use the rule to create an ambiguity. One must find the ambiguity first. The words should receive their ordinary and natural meaning unless this is displayed by a real ambiguity, either appearing in the face of policy or possibly by intrinsic evidence or circumstance. Now, paragraph 50, my lord. The aforesaid principle could be applied to the present case having regard to the nature of the policy in question. A medical policy, the specific queries in the proposal form and the answers thereto are given by the appellant in the context of the general and specified procedure. My lord, so this rule should be applied, my lord, against the drafter, my lord. Here, my lord, the clause you have also seen, my lord. This say arbitration will be, my lord, in accordance with the Arbitration Conciliation Act 1996 as amended. Another judgment is there, my lord, 2015-13 CC. Just time to be looked down. This is another, my lord, in respect of. Yes. Paragraph 13, my lord. Paragraph 13. Yes. It is equally well settled that while constituting arbitration agreement or arbitration clause, courts have to adopt a pragmatic, not technical approach. Arbitration agreement is not required to be in any particular form
what is required to ascertain whether the parties have agreed that if disputes arise between them in respect of subject matter of the contract, such disputes shall be referred to arbitration, then such agreement would spell out an arbitration agreement. So far, the first contention made by the learned counsel, I'm skipping over, well, now, paragraph 15, Manor. A perusal of the aforesaid provisions will show that in order to constitute an arbitration agreement, it need not be signed by all parties. Section 7(3) of the Act provides that arbitration agreement shall be in writing. What is mandatory requirement? Section 7(4) states the arbitration agreement shall be in writing if it is a document signed by the parties. But a perusal of clause B and C of section 7(4) show that a written document which may not be signed by the parties, even then it can be arbitration agreement. 7(4)(b) provides an arbitration agreement can be called out from an exchange of letters, telex, telegrams, or other means of telecommunication which provide for record. On reading of the provision, it can be safely concluded the arbitration agreement, even though in writing need not be signed by the parties if the record of agreement is provided by exchange of letters, so and so, so and so. This is not required. Next, paragraph 17. We are also of the opinion that commercial document having an arbitration clause has to interpret in such a manner as to give effect to the agreement rather than to invalidate it. On the principle of construction of a commercial agreement, explain that a commercial agreement has to be construed according to sense and meaning as collected in the first place from the terms used and understood by plain, ordinary, and popular sense. The learned author said that agreement has to be interpreted in order to effectuate the immediate intention of the parties. Similarly, Russell on arbitration opined that relying on extra company, so and so, so and so. The courts would, in the circumstance, allow lean in favor of giving effect to the arbitration clause to which the parties have agreed. The learned author has referred to another judgment so and so. In order to give emphasis that in construing arbitration agreement, the courts would seek to give effect to the intention of the parties. Then paragraph 18. The apex court in so and so must say it must be remembered that a contract is a commercial document between the parties and must be interpreted in such a manner as to give efficacy to the contract rather than to invalidate it. It would not be right while interpreting the contract entered into between the two laid-down parties to apply the strict rules of construction, which the ordinary applicable to a conveyance or other formal document. The meaning of a contract must be gathered from the adopting the common sense approach. It must be not be allowed to be thwarted by a narrow, pedantic, and legalistic interpretation. My lord, so far contra referendum is concerned, another judgment is there. Just one para I shall text, my lord. 2020 12 SCC 167. .10.
9.1?
10.
No, there is no 9.10.
This 9 my lord has different divisions, my lord.
9.1 is there.
No, next, my lord.
Oh,
Yeah.
oh, 9.910. Okay, okay.
This last sentence, last two sentences may be seen, my lord.
Yes,
That
sir.
it is well settled position of law that if there is any ambiguity or a term capable of two possible interpretation, one beneficial to the insured should be adopted, accepted consistent with the purpose for which the policy is taken, namely to cover the risks of on happening of certain event. Although there is no ambiguity in the expression, in fact, even otherwise, applying the rule of contra profundum, the use of the word impact in clause 5 of the instant policy must be construed against the appellant. Where the words of a document are ambiguous, they should be construed against the party who has prepared the document. The rule applies to context of insurance and clause 5 of the insurance policy. After reading the entire policy, the present case should be construed against the insurer. A constituent bench so and so, so. Well, same thing, well, constituent bench also same. Now here, well, your also is a sin. There, when the clause appeared, my lord, the clause appears just after the clause loss and other things. And this is why they have given it arbitration. If it is not the, my lord, the matter should be referred to arbitration.
all aspects to arbitration agreement, appointment of arbitrator, terms of reference, award, its effect will be in accordance with the provisions of Arbitration and Conciliation Act 1996 with amendments different. It's very clear, my lord, and their reply is the most important, my lord. Reply, they have said that two grounds we are refusing. That one, we have paid that, my lord, 147 year losses, must see again, my lord. 147. Para one say, my lord, the two grounds they have said. One is because they have paid the amount. Second, they say that arbitration clause is not as usually found in other standard general insurance policies. Well, this is not my fault, my lord. This is they are the document. They have drafted it. Page 147, my lord. This is very clear, my lord.
This insurance for what? Insurance,
My
insurance?
lord, that is burglary, fire, and other things, my lord. Shop insurance. So our claim has been denied on these two grounds. So my submission that they cannot take this plea that it is not as usual, my lord, in the other insurance policies, my lord. And this why this clause has been inserted?
Yes,
Arbitration clause.
yes, Mr. For your written argument. What is the written argument? There is no arbitration agreement. Second relates to reason for incorporation condition 50 is meant to provide. So, okay, 15 is not meant for 147, huh? That 15, what is the clause, arbitration clause? Page.
Arbitration clause, my lord, at page 44.
Page 44. Arbitration clause is 44. And notice. Reply. Is 157. Second ground. So your written argument is that your written argument is that
Per se
first-
is not an arbitration clause.
okay, clause 15 is not an arbitration
It's
clause.
if one goes to just a two-line sentence,
Hmm.
it's a shortest probably. It's not an arbitration agreement at all. And the reason why it is there, I was the to justify. Why
It
this
was-
particular clause is there?
Yes,
Lordship, in this case, I'd like to lordship, make familiar, your lordship with what the arbitration clause is in insurance policies. It was one of the cases decided by the Supreme Court. In Indian insurance versus engineering and construction.
that is in the
Let us show what insurance. Okay. You have to show what is there an arbitration clause in an insurance policy. There's no such, it's not an arbitration drafting mistake. It's not drafting mistake, it's not a yellow. It is intended to do so.
Mr.
If at all
BJ
there-
Ghosh, no?
I'm R Goswami, Lordship.
Sorry,
R Goswami,
R Gupta,
Goswami.
R Goswami. R Goswami. Insurance. Page number, para number,
I'll just say, pair number 20, Lordship.
para number,
Pair number, Lordship. Arbitration clause, it's in the second, pair number 2, Lordship.
para number 2.
Just to show, Lordship, what is the general shape and character of an arbitration clause in insurance policy. Shown of unnecessary effect, be it noted, and a whole this clause is quoted.
You are reading which one? This United India Insurance Company Limited.
Versus, yes, Lordship, and Hyundai versus Hyundai Engineering. Pair number 2, Lordship. The policy contained clause number 7, which reads as under. This is the arbitration clause. There are similar cases where arbitration clause has been put to interpretation. I'm just trying to show what actually is the shape of an arbitration clause in insurance. They are very detailed, and it also works out.
So what kind of claims will be?
Okay, what do you want to say by this judgment?
But it's, I think it's not so, that this is, not, his argument is that it's not a kind of usual arbitration clause. I just want to know what is the arbitration clause in insurance policy, and I'll come to this particular concern of question. This is where the dispute has arisen. Whether this per se can be considered a arbitration, whether it fulfills the section criteria of section 7. Perhaps it may read this clause is there. Once again, let's read it out. This clause in condition number page 44, let's see where it's noted, condition number 50.
Yes.
All aspects as to arbitration, appointment of arbitrators, terms of reference, award, etc., its effect will be in accordance with the provisions of the Arbitration Constitution 1996 as amended. There, it stops there. Just about 20 words.
Yes.
Thus, it is not an arbitration clause. It does not fulfill the requirement of the Arbitration Conciliation Act as per section 7. It has to be, there has to be some consent, consensus and item. Both the parties, there has to be some word, both the parties hereby submit themselves to the arbitration. Plus, the mere use of the word arbitration does not make it an arbitration clause. So I'll refer to one judgment, Jagdish Sandar versus Ramesh Sandar. It says again dealt with this particular relation. There it is given examples. There are so various clauses where arbitration word has been used. Even today, I cannot say that this shall be I'll read out process. It's in my argument. I have quoted from it, and this is the Jagdish Sandar versus Ramesh. That's because the word arbitration is used does not make this arbitration clause.
Now, in para 1, is that the rights obligation will so and so, in this country, as said, the policy number so and so which has been issued, which does not have an arbitration clause.
Yes, sir.
Okay.
It's just
And what is
an
it, Jagdish?
At all, sometimes one arbitration clause emerges through correspondences, through letters, or for some reference. Then this is the forum where we will go for arbitration. It will be bound by arbitration conciliation act. Just to enable arbitration. It's not an arbitration clause itself, by itself.
In Jagadish,
Jagdish Chandra versus Ramesh Chandra.
what is that?
Let's say may come to this. I'll just read out from my.
Para?
I'll read out.
Para?
This was one. I've just given the copy. I'm trying to find the second copy. I'll read out the first one. There's a second copy. I'm just trying to. Para 7, Lordship. Para 8 also. It's again known as arbitration clause of a partnership deal. In that clause, the para in the para 2, Lordship. It says what the arbitration clause in the partnership deal. Then why it can't be called the arbitration clause. Similar, just the mere use of the words arbitration doesn't make it arbitration agreement. If I may read, Lordship, the reference to this particular example. If during the continuance of this partnership or at any time afterwards, any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. I mean, this was not held to be arbitration. There's some kind of indication the parties shall determine. But since it was in future tense, if the parties so determine, and here we do not find any word that of consent at all. Section 7 says that's contractual, core contractual requirement. A core contractual requirement is consensus. Consensus added. This has to be also bidder only of last, I'll go to last 244, last paragraph of bidder only also. It just says the court has to. Bidder only is a 244.5 lordship.
Vidya,
Bidder only lordship. Versus Durga Trading Corporation. Lordship, this has been referred to by your lordship in one of the decisions from
citation, Vidya Drolia,
Bidder only is a 2021 to SCC 1.
021,
2
SCC,
SCC page 1.
page 1.
I'm going to page number 162.
Yes, 1,
62, page number 162, pair 244.5.
page number 160,
Page number 162,
para number
244.5.
yes.
The scope of the court to examine the prima facie validity of an argument includes only whether the arbitration agreement was in
Yes.
writing in this case, whether the arbitration agreement was contained in an exchange of letters, communications, etc. in this case, no. Because the only letter they had written to us were denied, is not agreement. If it was denied and we did not, it was alleged and we did not deny it, then also that may have been constituted. It's one of the subtle question of law. They alleged and we said we did not say anything, we did not deny. Then whether the core contractual ingredients qua arbitration agreement was fulfilled. Core contractual requirements, ingredients are consent, legality, consideration, etc. Yet the consent is not there. The reference, the willingness to submit to arbitration. That is the core. And that's qua the arbitration. So this is here says this Jagdish Chandra throws the light is only on this point that mere use of the word arbitration does not make it an arbitration clause. He also held that. And lordship, my written argument that contra proferentum lordship. Can it come for a hearing lordship again? I have not finished. Another date will be given lordship.
Wednesday. Hearing will continue Wednesday. Our Mr. Saiwal Anani Senegal, assisted by Mr.
HK Sharma.
HK Sharma. Also Mr. R. Goswami.
I will send.
For insurance. Hearing will continue on Wednesday.
All right.
If I come with item number 1, my lord.
I don't know that I can't say. Computer will decide. Next.
Item 10.
Yes, you say what is the internal, what do you want?
But on a short point, I have filed this review petition.
Okay,
But Lordship has directed consideration of the case of the petitioner as per clause 15 of the OM for compassionate appointment in respect of other department he will now be considered. But his case was rejected by the SLC at earlier point of time. But kindly indicate that it will be considered by the DLC as per clause 15. That portion is not in the order.
Just
no, if I consider SLC, let the DLC do it.
My DLC has to consider as per clause 15. That much I pray.
does the word authority not clarify?
Which one? Para 5.
Para 5.
Required
The authority. The word authority may be clarified.
So the DLC will decide.
DLC will decide as per the clause 15 consideration will be given by the DLC.
Okay.
That is not my prayer.
Okay, Land Council for the state, also Mr. Land Council for the writ petitioner. The present application review preamble 5 for seeking clarification of the order dated 1/3/2019 passed by this court in WPC number 1406/2019. It has been submitted as the case of the petitioner was earlier decided by the SLC.
Yes, sir.
And as such, if the case of the petitioner has to be reconsidered again, it has to be placed before the concerned DLC, which shall do the needful after examining the availability of vacancy in the concerned department, in other departments,
Yeah.
in other departments. Full stop. Accordingly, the order passed by this court on 1/3/2019 is clarified by holding that direction issued is content clarified within courts, the authority may have will be read as follows. The concerned SLC may examine the availability of the vacancies at the department, which shall be undertaken by the authorities within a period of 3 months from the date of receipt of a certified copy of this order. You okay, that's all?
The DLC.
DLC, the authority I have, instead of authority, I have mentioned DLC.
DLC. DLC, in fact, DLC Barpeta.
DLC Borpeta.
Yes, Lord.
With the above clarification, the review petition is disposed of.
No.
Item 11.
What is item number 11? What is it? Devendra Kumar, what is this? What is this matter of
Yes, please. Like this IML, we are praying for restoration, my lord.
restoration?
Yes, sir.
Any objection? If you have objection,
I have filed the objection, my lord.
okay, you have filed objection, then let it come out after vacation then. Because if there is
Fine.
objection,
Lord.
they have been submitted, the objection has been filed to the restoration application. In the view of the matter, this is the matter again on so and so.
2016. Please stop.